Good morning, everyone. This is Chair French convening the hearing on the unanimous settlement agreement in the matter of the application of Evergy, Kansas Metro, Evergy, Kansas South, and Evergy, Kansas Central for approval of a large load service rate plan and associated tariffs in docket number 25 EKME 315 TAR. We are on the record now in that proceeding. To those of you participating online, please bear with us if you experience any technical glitches. We will begin with the entries of appearance from all the parties, and I will start with Evergy.
Morning, Chairman. Kathy Dingus and Caitlin Shields on behalf of Evergy Kansas Central, Inc. and Evergy Metro, Inc.
All right, good morning. We will now go to KIC.
Good morning, Commissioners. This is Jim Sikora. Also entering appearance will be Lee Smithyman, Dan Buller, and Molly Morgan of Fulston. And the appearance, please, is on behalf of Goodyear Tire and Rubber, Kansas Industrial Consumers Group, Associated Purchasing Services, Occidental Chemical, Spirit Aero Systems, Lawrence Paper Company, USD 512, which is the Shawnee Mission School District, USD 229, which is Blue Valley School District, USD 233, which is Olathe School District, and USD 232, which is DeSoto School District. Thank you.
All right, thank you, and good morning, Mr. Sikora. We now move to the Data Center Coalition.
Good morning. This is Elisa Greenwald on behalf of the Data Center Coalition.
All right, good morning, Ms. Greenwald. For Panasonic.
Good morning, Commissioners. James G. Flaherty, Ottawa, Kansas, appearing on behalf of the intervener Panasonic Energy Corporation of North America.
All right, thank you, Mr. Flaherty. We will now move to counsel for Google.
Good morning, Commissioner. On behalf of Google LLC, Frank Caro, Andrew Schulte, and Jared Jevons with the Polsinelli Law Firm.
Good morning, Mr. Caro. We will now move to Curb.
Yes, good morning, Commissioners. Joseph Astrab, Consumer Counsel, appearing on behalf of the Citizens Utility Ratepayer Board, or CURB. Thank you.
Morning, Mr. Astrab. And finally, counsel for KCC staff.
Yes, good morning. This is Carly Massentine, and Patrick Hurley as well will be representing staff.
Good morning, Carly. And we will stick with you, Carly, now that we've finished entries of appearance. Let's turn to notice of this hearing this morning. Do you have a recommendation regarding notice?
Yes, staff recommends a finding that notice was proper. KSA 77-518 mandates that notice of a hearing conducted pursuant to the Kansas Administrative Procedure Act shall be issued to all parties at least 10 days prior to the hearing. The Commission issued an order modifying the procedural schedule on August 21st, 2025, in which it converted the evidentiary hearing to a one-day settlement hearing on today's date. This order was served upon all parties. Therefore, staff recommends a finding that notice was proper.
Are there any objections to such a finding? Hearing none, I will find that notice is proper and the Commission has jurisdiction to hear this proceeding at this time and place. Let me now turn to a few preliminary matters before we get into the meat of the proceeding. Just to note that we are conducting this hearing via Zoom. So if any party encounters a technical issue, please just first immediately ask us to go off the record so we can resolve the technical issue off the record, and then we can go back on the record. Second, witnesses participating on Zoom are asked to keep your microphones off when you're not scheduled to talk. Third, if the Commission needs to deliberate, we will go off the record. We will enter what's called a Zoom breakout room where we can't be seen or heard, and then we will return. And finally, as we're participating at a distance, please be very careful to identify pre-filed testimony and exhibits. We should have copies of everything that's been filed in this proceeding, and we should be able to follow along as long as everyone is very clear with what they're identifying. Next preliminary matter, I understand at the pre-hearing conference, the parties indicated their intent to move forward with a motion to admit all the pre-filed testimony into the record. Is there someone that is planning to present that motion to have all that testimony admitted?
Yes, Chair French, this is Carly Massentine with KCC staff. I would move to admit all existing pre-filed testimony. So that's direct testimony, cross-answering testimony, rebuttal testimony, and settlement testimony into the hearing record.
Any objections? All right, hearing none, all the referenced pre-filed testimony and exhibits will be admitted into the official record of this proceeding, whether or not we call witnesses up for additional questioning. Are there any other preliminary matters that we need to address? Hearing none, we will move on to a description of the procedure for our hearing today. I understand that Evergy will be making a brief opening statement followed by opening statements by KIC, Panasonic, Data Center Coalition, Google, Curb, and staff. After those opening statements, we will follow the order of witnesses agreed to in the pre-hearing conference. We may pause before the witnesses to see if there are any that we can dismiss based on whether the commissioners know if they have any questions for those witnesses, but we'll tackle that after opening statements. And I do understand that at the pre-hearing conference, the parties indicated they will not be making closing statements. So with that, we will turn to opening statements, and I will turn to Evergy. And I believe you can share your presentation unless our IT staff has that.
Good morning, Mr. Chair. And yes, I will try screen sharing and hopefully this.
If not, our IT staff, oh, there it goes.
Yeah, we see it.
Great, you can see it?
We can see it. If you're able to make it full screen, that might be a little better, but it's we just see the Adobe screen now, but it looks okay.
Let's see. Okay, is that up?
If it's easier, our IT staff should have copies of the slides as well if we want to go that direction.
Let's see.
I think we have the same. You can do Control L to go full screen.
Okay, hang on. Thanks for bearing with me. Okay, Control L. How does that look?
Oh, perfect. That's
There you
wonderful.
go.
All right, please proceed.
All right. Well, good morning, everyone, commissioners, and everyone else who's here this morning. I am Caitlin Shields of the law firm Wilkinson Barker-Nauer. I'm here today with Kathy Dingus of Evergy, and we are here on behalf of Evergy Kansas Metro, Kansas South, and Kansas Central, which we'll refer to collectively as Evergy or the company. Today, I'm pleased to provide an overview of the LLPS rate plan and the unanimous global settlement agreement. I will also explain why the settlement agreement is reasonable in the public interest and why it should be approved without modification. So first, I'd like to provide a brief context for why we're here today. We filed our large load power service rate plan, or LLPS rate plan, application on February 11th. Today, it seems rare that a day goes by without seeing a news story, trade article on large loads, data center, AI, and electric load growth. Evergy recognized this shifting landscape pretty early. They put a lot of front-end work into developing a plan that would allow Kansas to capture the benefits of large loads. Large loads present significant economic development opportunity for Kansas. Policymakers recognize this. The business community recognizes this. And so this proceeding, hopefully, as it reflects, we think Kansas is very well positioned to capture these benefits. Evergy is actively managing a queue of more than 6 gigawatts of potential new load across its footprint. That includes not just data centers, but advanced manufacturing as well. And with the right regulatory construct, this will translate into jobs, tax revenue, economic growth, and rate benefits to existing customers. Now, the benefits certainly do not come without risk. Nationally, demand for electricity is outpacing the available supply from the generation fleet. So in order to accommodate today's demand, utilities are being asked to invest significant capital in generation and transmission assets, which often take years to construct and have multi-decade lifespans. So this raises the question about certainty and the staying power of large loads. In the utility rate-making context, this translates into risk of cost shift and stranded assets. So the good news is that risk can be managed through smart rate design and commercial terms. Evergy is confident that we can capture the benefits of large loads while also protecting customers from undue risk. So the Schedule LLPS rate plan, it was with this context in mind that Evergy developed its LLPS rate plan. In developing our application, the Evergy team spent a lot of time engaging with prospective large load customers and other stakeholders. And through all of that front-end work, identified a number of key objectives for the LLPS rate plan. So first and foremost, we see little point in developing a tariff that no one enrolls in. So it's really important that we developed a tariff that would actually attract new customers, a tariff that would keep Kansas competitive, and at the same time, a tariff and program that would protect non-participants. So this meant that the plan needed to establish clear and transparent processes that allow Evergy to efficiently respond to the increasing demand, but also provide some optionality in terms of things like load flexibility, clean energy options, while also ensuring that we protect non-participants. So to do this, we integrated a number of important protections, including, for instance, a minimum service term, a minimum demand charge, a minimum bill, credit and security requirements, and strict early termination fees. And in developing those, we took perspective on the national landscape and what we had already started to see emerging nationally. It was important, though, from Evergy's perspective that with respect to rates, we really wanted to ensure that we had clear rules for transmission cost responsibility and that there was a demonstrable rate benefit to non-participants. The LLPS rate plan and the settlement agreement accomplish these objectives. So after filing the LLPS rate plan in February, we established a unique two-part schedule that included a number of procedural opportunities for settlement. So in addition to engaging in the traditional discovery process, Evergy hosted, by our count, I believe, 7 technical conferences, with each one focused on a unique component of the LLPS rate plan. We additionally held a number of smaller group working sessions. We had numerous hours of settlement negotiations, again, by our counts, at least 40 hours. And through all of that effort, through all of that work, we reached a unanimous and comprehensive settlement agreement. And that's the settlement agreement that's before you. In Kansas, there's a 3-part test for approval of settlement agreements. A settlement agreement must be backed by substantial evidence, result in just and reasonable rates, and be in the public interest. Here, we maintain that the settlement agreement meets the KCC's 3-part test for approval of settlement agreements. This includes substantial evidence from Evergy witnesses, along with a series of settlement witnesses who filed their testimony as well. We have a settlement agreement that results in just and reasonable rates. We also have a settlement agreement that's overall in the public interest. To walk through some of those, first and foremost, robust customer protections. So some key features of the settlement agreement, which I'd already walked through, many of which were in initial form in the LLPS rate plan. Through the course of settlement, we've been able to tweak and refine some of these. We preserved a minimum bill requirement, a demand charge requirement, and a minimum term. So these features together are going to ensure the staying power of large load customers, ensuring that they come to Kansas and they stay in Kansas. The settlement agreement also establishes clear collateral and credit requirements So this is going to ensure that only serious and financially viable large load customers enroll in the tariff. The settlement agreement maintains exit fees, capacity reduction fees. Both of these will serve to mitigate rate impacts in the event a large customer leaves the system or doesn't materialize at their forecasted load level. And then last, and perhaps most importantly, is that the settlement agreement ensures large load customers will provide affirmative rate benefits to non-participants. Through the settlement agreement, this is through a demand charge that's set above the embedded cost to serve. Some of the other things I mentioned earlier at the outset are the need for some flexibility and clean energy options. So again, through a lot of our outreach and engagement before filing, as well as through settlement dialogue, we realized just how important it was that we have a number of clean energy options, load flexibility options for large customers. So the settlement achieves this through a series of clean energy rate rider options. There's a demand response and local generation rider, a renewable energy program, green solutions, alternative energy credits, clean energy choice rider, all of which were designed with large load customers front and center, being able to provide optionality, flexibility, and at the same time in a smart, responsible way to ensure that non-participants aren't harmed. Now, the settlement agreement also promotes efficiency and certainty. Something really unique to the settlement agreement, also the LLPS rate plan, is the path to power. The path to power includes clear parameters for upfront payments, as well as the interconnection study process that Evergy will follow to evaluate and interconnect large load customers, providing customers and all stakeholders with a sense of certainty and understanding as to how the interconnection process will flow. Now, importantly, the settlement agreement promotes economic development. It achieves our objective of ensuring that we have a mix of consumer interests and large customer interests. So we have a handful of important tools here. We have a competitive tariff design. Again, we've taken stock of some of the national trends across large load tariffs, wanting to make sure that we have a tariff that's competitive and at the same time protective. We also wanted to make sure that we have some tools that are actually going to attract large load customers. I think the path to power process is something that's a key feature in doing that, as well as really detailed provisions, just clearly identifying step-by-step risk allocation and really what large load customers need to do to put some skin in the game and to enroll. At the same time, by attracting large load customers, we will drive local benefits. That includes jobs, tax revenue, economic growth. And again, we'll be able to, through the additional load, we'll be able to share spread fixed costs over larger rate base, hopefully providing some rate mitigation and stabilization benefits for all customers. Additionally, through the course of settlement, we landed on some transparency provisions. So the company agrees to annual reporting to the commission to keep the commission informed of the status of its large load program. We've committed to holding regular meetings with staff and CURB related to large loads. And then the KCC is going to maintain oversight through future rate cases, where the commission will have the opportunity to evaluate the rate making structure associated with the LLPS rate plan, particularly as we have customers come online. So last, in conclusion, we believe that we've brought forward a really thoughtful settlement agreement. It's a unanimous settlement agreement with a broad suite of interests who have signed on. We have large load customers, we have consumer interests, conservation and environmental interests. It's supported by substantial evidence, results in just and reasonable rates, and overall, we maintain that it's in the public interest. So for that reason, the LLPS rate plan is modified and set forth in the settlement agreement, ensures large load customers pay their fair share, protects existing customers from undue harm or cost shift, and it's going to promote economic development. So we're confident that the LLPS rate plan is a win for Kansas, it's a win for customers, and it's a win for large load customers. So with that, Evergy respectfully requests the commission approve the settlement in full. I'd also note that to support the settlement agreement, Evergy is happy to make Mr. Darren Ives and Mr. Brad Letts available for further questions. And we thank you very much for your time.
All right, thank you, Ms. Shields. With that, we will turn to our next opening statement and Mr. Zakura representing the KIC group.
Thank you, and thank you, commissioners, for the opportunity to make an opening statement. KIC in the school
Before, I'm sorry to cut you off. Ms. Shields, can you stop sharing your screen? That way we can see Mr. Zakura in his full glory. All right, thank you. Mr. Zakura, you may proceed.
I would settle for part glory. Thank you, not full glory. Thank you, and thank you for the opportunity for presenting an opening statement. KIC and the school districts are signatories to the unanimous settlement agreement, and we fully support its terms and conditions. Our client group had three main objectives in this docket. Number one, to protect existing retail ratepayers from rate increases by assuring that data centers pay their full cost of service. Number two, develop a good tariff that would be supportive of data centers located in Kansas. And number three, encourage data centers to bring generation capacity to serve their load, both existing capacity they own or control, and by constructing additional generation capacity in Kansas. We're fortunate to have Mike Gorman advise us in this case, and Mike Gorman and Brubaker are looking at these types of tariffs throughout the country. So I want to call out that Mike was a valued advisor in this case. We believe that the settlement agreement accomplishes these goals. We were fortunate to have direction from the Kansas legislature in this matter in the form of Senate Bill 98, which was passed by the legislature on April 11, 2025, and signed into law by the governor on April 24, 2025. Evergy is to be commended for filing a comprehensive tariff proposal for data centers that was thoughtfully constructed and contained optionality for data centers rather than a one-size-fits-all approach. By presenting service options to data centers, Evergy permitted data centers to address their mission statements in a variety of ways and opened the door to the unique aspects of Kansas that will be vital to the development of data centers in Kansas. I am speaking specifically of the customer capacity rider that permits a data center to bring its own or control generation to serve its load. Evergy recognized that large load customers have acquired renewable generation capacity as a part of their business model, and that the associated generation capacity could be used to both support and hasten data center operations. Why is optionality important in this docket? Because when it comes to energy, Kansas has it all. Large amounts of existing and expandable renewable energy, coal and natural gas generation, nuclear power, and battery storage on the horizon. Kansas has generation assets that can bring to life this option. An LLPS tariff with a term of 12 to 17 years is of sufficient duration for a data center to consider all types of generation capacity additions, both renewable and dispatchable. Before going further, I want to thank KCC staff, CURB, the Data Center Coalition, and Google for their participation in the discussions that led to the unanimous settlement agreement. Each party presented their positions skillfully, but were willing to compromise for a settlement that was best for the most Kansans. For the last decade, Evergy has not experienced load growth on its system. LED lighting, more efficient windows, siding, insulation, and only modest population increases have resulted in flat electric volumes. At the same time, costs increase, particularly transmission costs. Data center use holds out the opportunity to reduce retail electric rates for all Kansans by spreading fixed costs over a greater volume of sales. Thank you so much. I appreciate the opportunity.
All right, thank you, Mr. Sakura. We will now move to Mr. Flaherty for Panasonic.
Yes, good morning, commissioners. As the commission may know, Panasonic and Evergy have recently filed a special contract, and the parties have asked the commission to consider and approve that contract on an expedited basis. Panasonic intervened in this LLPS tariff docket because it wanted to make sure that if, for any reason, its special contract is not approved, Panasonic would continue to receive service under the ILP tariff, and that the new LLPS tariff would not apply to Panasonic. As Evergy's witness, Jason Clint, stated in his pre-filed testimony in the special contract docket, the new LLPS tariff was not intended to apply to Panasonic, and no party to this docket has disagreed with that intention. Since the tariff is inapplicable to Panasonic, it did not join in the settlement, but it would like to state for the record that it has no objection to the settlement proposal. Thank you.
Thank you, Mr. Flaherty. We will now move to Ms. Greenwald for the Data Center Coalition.
Thank you. Good morning. My name is Elisa Greenwald, and I'm one of the attorneys representing the Data Center Coalition in this case. We greatly appreciate the opportunity to provide a brief opening statement. So before I jump in, let me start with some quick background on DCC. DCC is the National Association for the Data Center Industry. It represents leading companies who own and operate data center infrastructure across the country and across the globe. So you've heard from parties already that the reason we're here, the impetus behind Evergy's application, is a surge in requests for service from large load customers, including data center customers like DCC's members. These customers represent a massive opportunity for the state of Kansas. They're likely to invest billions of dollars in the company's service territory, create good-paying jobs in construction and information technology and maintenance, diversify the state's economic and industrial base, and bring in significant new revenues that will help the company spread fixed cost of its system over a larger customer base. With all of that said, the problem that the company is trying to solve here through its proposed LLPS tariff is to mitigate the risk of stranded costs and cost shifting to other customer classes if large loads do not materialize as the company expects. That's the objective motivating the substantial new customer protections that Evergy proposes in this case, including long-term contract commitments, minimum demand charges, termination fees, and financial security provisions. Rather than negotiating these protections on a one-off basis with individual large loads, Evergy proposes to move these protections into a tariff, recognizing that the company has a queue of large loads requesting service. DCC believes that it's highly likely that the large loads Evergy forecast will materialize, but nevertheless supports reasonable customer protections and supports the creation of a tariff that reflects these protections. As this commission is likely well aware, while Evergy is certainly an early mover, regulators across the country are considering utility proposals to impose new requirements on large load customers. Those proposals generally aim to leverage the opportunities electric load growth will bring while mitigating its risks. DCC is active in many of those cases and has routinely supported reasonable policies that accommodate load growth in a thoughtful and deliberate manner so as to mitigate the risk of stranded costs. In this proceeding, we were able to reach a unanimous settlement agreement with the parties to this case. While I will, of course, not get into the substance of settlement negotiations, I can say that a lot of hard work and difficult conversations went into negotiating the settlement agreement here. DCC supports the settlement agreement because we feel that it strikes a balance. It gives large load customers, including our members, a reasonable opportunity to do business in the company's service territory, allows customers modest flexibility, but also guarantees significant minimum revenues from large loads to protect other customers from cost shifting. The suite of customer protections included in the proposed settlement is not identical to customer protections that other utilities have adopted, but that's not surprising because every utility is necessarily different. However, those protections are reasonably in line with where other utilities have landed when trying to answer the same questions. We therefore urge the Commission to adopt the settlement as a reasonable resolution of this case. With that, I'll conclude my opening statement, and I encourage the Commission to ask questions of DCC's witness, Kevin Higgins. Thank you so much for your time.
Thank you, Ms. Greenwald. We will now turn to counsel for Google, Mr. Cairo.
May it please the commission. Good morning, commissioners. I hope you can hear me well.
Loud and clear.
On behalf of Google, thank you for the opportunity to be here today. We appreciate the leadership that Kansas has shown on the issue of large loads, including the proactive tariff filing by Evergy, the cooperation of staff, CURB, and the diverse set of parties to reach a unanimous, comprehensive settlement agreement, and the diligence of the commission in presiding over this pivotal case. We wish to thank all the parties for their efforts during settlement negotiations to craft a collaborative, fair, unanimous, comprehensive settlement agreement acceptable to all parties. Before addressing the merits of the settlement before you today, I want to provide some background on Google's efforts to develop data centers responsibly across the region and the country more broadly. Given the increased focus of data center load growth and artificial intelligence, or AI more broadly, we believe that it is important to state why and how Google approaches data center development across the state, region, country, and globe. Google's data center development and investment more broadly is defined and informed by the following pillars: advancing vital infrastructure, building the necessary infrastructure of tomorrow to support connection, digitization, and prosperity for all. Next, accelerating the economy, bringing more economic activity, new businesses, and growth opportunities to the communities we call home. Next, investing in the communities, collaborating with each community to provide long-term support through grants, educational programs, and other initiatives, and through innovative, sustainable solutions, driving advancements in sustainability every day by accelerating the clean energy transition, continually improving efficiency, and preserving critical natural resources. As Google makes business decisions regarding growth in the region, clear policy signals and regulatory frameworks are key components helping Google make informed, long-term business decisions. The current dynamics within the energy industry and the global economy places us in a historic and evolving environment. Google's view is that this dynamic requires an active commitment to develop and advance new solutions, which should be the result of a deliberate process that considers the input of all affected stakeholders, helping us to advance our shared goals. The unanimous comprehensive settlement agreement reflects this deliberation among a variety of parties to reach a fair compromise that addresses the needs of each stakeholder. Additionally, Kansas's long history of affordable, reliable service, coupled with its forward-looking regulatory structure, makes it well-positioned among states competing for large-scale data center and AI investment. That is why Google views Kansas not just as a location for new facilities, but as a partner in building the infrastructure of the digital economy. Moving forward, risk management and financial risk-sharing structures are central to this discussion. As everyone in the room or on the video knows, utilities and ratepayers more broadly have historically borne the investment risks associated with demand forecast inaccuracies. As a good corporate and grid citizen, Google recognizes that at current demand projection levels, which include artificial intelligence, cloud computing, and policies supporting the onshoring of advanced manufacturing, it is important that the costs and benefits of new infrastructure are appropriately balanced and assigned. While Google recognizes that projections of new load growth have raised concerns among a wide variety of impacted parties, we believe this situation presents a unique opportunity. This is a chance for regulators, customers, and utilities to establish partnerships that can be leveraged to power the digital economy moving forward. The Commission should adopt the unanimous comprehensive settlement agreement in this case because it falls within the emerging industry standard and protects existing customers. These protections ensure that other customer classes' rates will not reflect any unjust or unreasonable costs associated with service to large load customers. Thank you again for the opportunity to be here today and your consideration of the evidence presented in pre-filed testimony and throughout this proceeding. Google's witness, Dr. Carolyn Berry of the Bates White firm, is in the virtual hearing room this morning and looks forward to responding to your questions regarding the emerging industry standard for large load tariffs and the appropriate balance struck by the unanimous comprehensive settlement agreement filed in this case. Again, thank you for your consideration.
Thank you, Mr. Cairo. We will now move to counsel for the Citizens Utility Ratepayer Board, Mr. Joseph Astrab.
Thank you, Chair. Good morning. My name is Joseph Astrab, and I am the Consumer Counsel for the Citizens Utility Ratepayer Board, better known as CURB. We are the state agency tasked with representing the interest of residential and small commercial ratepayers before the Kansas Corporation Commission. CURB is here today in support of the unanimous settlement agreement establishing rates and tariffs for new large load customers in Kansas. Many states, including Kansas, are facing new challenges associated with the advent of large customer load growth, particularly from data centers. Such customers use vastly higher quantities of electricity and resources than even the largest existing customers today, prompting new investments into the system. At the same time, there is an opportunity for states to attract new business and promote economic development through this expanding industry. In light of these circumstances, CURB recognizes the importance of developing rates and tariffs to account for the unique characteristics of large load customers while protecting ratepayers from unreasonable burdens. CURB will present the testimony of its witness, Josh France, to discuss CURB's role in this docket and the considerations that led us to support this agreement. At the forefront, CURB was concerned that present-day tariffs could be inadequate to account for the costs needed to serve these customers. Alternatively, each new large load customer could elect to negotiate directly with Evergy for a special contract with its own rates and conditions. Neither option appealed to CURB as a long-term strategy to fold such customers into the system. Over the course of several months, CURB engaged with utility, regulators, and various stakeholder groups, including potential new large customers, to study projected load growth and design provisions that would represent recovery of additional incurred cost. Not only does this agreement establish reasonable rates for large load customers, the tariffs represent a foundation from which to build as new customers take service. CURB helped advance terms and conditions that protect customers from unfulfilled agreements and stranded investments, such as extended service terms, exit fees, and lower thresholds for applicability. While significant effort went into crafting this settlement agreement, CURB believes that the work on rates and tariffs for large load customers is just beginning. Mr. France will tell you about CURB's lingering concerns associated with large load growth, especially from the potential for significant capital investments in long-lived generation assets and the relatively shorter service terms for customers. He also highlights the risk of under and over projections with large load growth and the consequences of missing the mark. Despite those issues, CURB believes that the agreement represents a significant improvement over the status quo and provides reasonable terms and conditions to promote new business growth in Kansas while providing for the recovery of costs to serve them. As new large customers take service and we obtain real data and experience about the impacts, CURB expects stakeholders and regulators to continue reviewing rates and provisions that benefit both new and existing customers. At the conclusion of today's presentation of evidence, CURB will join the other signatories in asking the Commission to approve the unanimous settlement agreement. Thank you.
All right, thank you, Mr. Astrab. And we will conclude with KCC staff and Ms. Mazzantine.
Yes, thank you. The settlement before the Commission today, as others have already stated, was uniquely derived in that it is the product of the most extensive settlement negotiations that I personally have been involved in during my time at the Commission. And that effort led the parties to reach a unanimous settlement. Parties that, on the subject of large load customers entering Evergy's territory, have very diverse and even competing interests. But despite those diverging interests, it was understood by all parties to this case that the question of appropriate charges and rate design for large load customers was hugely important across a myriad of interests in this state. And for that reason, the parties put forward a collaborative effort to craft a tariff that protects Evergy's other customer classes from exposure to the costs associated with incoming large load customers, without being so onerous as to discourage large load customers from entering Evergy's territory. As detailed in the settlement testimony of staff witness Justin Grady, who is present today to further testify to this, the settlement is based upon substantial competent evidence, will result in just and reasonable rates, and is in the public interest. And for those reasons, staff supports it. Thank you.
Thank you, Ms. Mazantine. All right, we have concluded all opening statements, and we are ready to begin our examination of witnesses. Before we begin calling witnesses, I just wanted to check with the other commissioners on whether we could preemptively release any witnesses. I know that I will not have questions for Mr. Lutz and Mr. Gorman and Mr. France. Do either of the other commissioners have questions of those two witnesses or those three witnesses?
I do not.
Yes, Chair French. I have questions of Mr. Lutz.
Okay, so
Not so of the others you mentioned.
that leaves us Mr. Gorman and Mr. France. And unless I hear objection, I think, of course, those witnesses are welcome to stay on and participate in the hearing, but we would not expect to call them. Commissioner Keen?
Pardon me. Yes, thank you. I'm sorry to interrupt you. Yes, I have questions of Mr. Gorman.
Oh, okay. All right. Well, then that may just be Mr. France that we are releasing then at this time.
Yeah. No objections there, commissioners. Thank you.
Okay. Very, very well. All right. We will then go ahead and proceed with our first witness, and I understand it will be from Evergy. So, Ms. Dingus, you may call your first witness.
Thank you. Evergy calls Darren Ives.
Good morning, Mr. Ives. If you could please raise your right hand, and I believe we have a court reporter here to swear you in.
Good morning, Mr. Ives. Do you swear that the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Counsel, your witness.
Thank you. Please state your name and business address for the record.
My name is Darren Ives, I-V-E-S. My business address is 1200 Main, Kansas City, Missouri.
Mr. Ives, you filed both direct testimony and testimony in support of the unanimous settlement in this docket. Is that correct?
It is.
And that testimony has already been admitted into the record. So I believe we are ready for commissioner questions.
All right. Thank you, Ms. Dingus. We will begin with commissioner questions, and I will start with Commissioner Keen.
Thank you, Chair French. Good morning, Mr. Ives.
Good morning, Commissioner Keen.
What I want to do first is I just have a few questions for you. To turn to your direct testimony, in particular, I'm looking at page 5. I don't know if it matters that we do a screen share. It might help if, Michelle, if you can do that.
Which PowerPoint are you needing?
It's page 5 of Mr. Ives' direct testimony.
I don't have those documents.
Okay.
I just have the PowerPoint.
Okay, I got you.
So if Mr. Ives has that, he can share.
Darren, it's not absolutely necessary. I can actually read in what are basically lines 9 through 13, and I think that would be adequate if you could indulge that approach.
You bet. Or I could read it in. I have it available.
Let's give it a shot. Again, I'm reading from Mr. Ives' direct testimony. It's on page 5, lines 9 through 13, and they read as follows. Not only is the scale of new large customer load drastically increasing, but many large customers have ambitious clean energy and emission reduction targets. For example, 75% of the respondents to the Area Development Magazine's corporate survey in the first quarter of 2022 indicate that access to renewable sources of energy are very or somewhat important to their companies. That's the end of the portion of Mr. Ives' testimony that I'm reading into the record. Here's my question to you, Mr. Ives, in view of this testimony. What impacts could this scale of increasing load and the desire for these energy meeting certain emission reduction targets, what could this have on the future of transmission build out and costs?
So thanks for the question, Commissioner. That's a tough one. We have well, I guess what I'd start by saying is we're super well situated in Kansas from a renewable standpoint as we set today, right? Compared to a lot of areas of the country. We have a great set of wind resources available today. We also have a fair amount of solar and certainly a lot of solar potential in Kansas. That said, these customers and they can speak to it as well, that they are very active on their own accord in consideration of renewable resources, and that was part of what we wanted to make sure we unlocked with some of the flexibility of the tariffs. We have opportunities to allow them to bring their own capacity toward serving their load. That does a couple things, right? It helps them utilize some of the resources that they have engaged in that are renewable in nature. It also allows them to participate in helping advance the speed to getting them online and to market. If they can bring resources that we don't have to go out and construct from scratch as part of the solution set, certainly if it works for us as well as for them, it helps from a speed standpoint, and it helps from a utilization of some of the available renewable resources that they participate in. So probably last thing I would say is the other thing, Commissioner, that we did by putting this together in a tariff format is that we're going to be able to continue to evaluate the implications of transmission build or supply build and make sure that we as a collective group of stakeholders are continuing to look and getting our cost allocation and cost recovery appropriate aligned across the classes of customers, both the prospective new large load customers and existing customers. It was one of the benefits of going through this rate plan and this tariff proposal that we've all put in front of you.
Thank you for that response, Mr. Ives. It was characteristically granular, and I appreciate the level of detail that you incorporated into your response. Let me follow that up with let's take the circumstance where the prospective new customer does not provide their own renewable or other resources, where they would rely upon the Evergy system to provide that. I'm looking at an article. It's from Utility Dive magazine. It was published on October 1st, 2025. The article I'm looking at, the caption to the article is customers in 7 PJM states, and PJM, for those listening in, is an East Coast regional transmission organization, that these customers paid $4.4 billion for data center transmission in 2024. Under the brief summaries of the article, I'll read 2 sentences. First is, utility customers in 7 PJM interconnection states are being charged $4.4 billion for transmission upgrades approved last year, needed to bring data centers online, with similar results expected this year. And another sentence that tries to capture the essence of the article states, the cost for local transmission needed for data centers falls into a regulatory gap, with the expenses for the upgrades typically being shared by all customers within a utility's footprint. Given that backdrop, Darren, my question to you is this. Is there a risk that an analogous circumstance could happen under the terms of the settlement agreement in this docket?
Well, I would never say no risk, but I think the value of the settlement agreement is that we've substantially mitigated the risk. There's a couple ways that we've done that. First, with the path to power and some of the work that's embedded into the rate plan, it's very clear that directly incurred transmission cost for the connection of prospective large load customers, things that are identified to directly support and serve their interconnection are all going to be directly assigned and paid for by the specific large load customer. So there's no gap in that regard from anything that's directly assigned. And then from a a broader upgrade standpoint, as we run through the path of power and we work with SPP to identify any needed system upgrades to more broadly meet the needs of bringing these large loads online, those will run through the traditional SPP processes, so they'll be cost allocated consistent with the methodologies that are set out and established through the RSC and ultimately approved through FERC. So there will be a process for that work to be evaluated, to be deemed to be appropriate through the SPP processes, and then ultimately come through the customers. That will have an impact to all customers, but as you know, part of the evaluation when the SPP does that work is to look at cost benefit and ensure that there are appropriate benefits to customers on the system by making those upgrades. So we feel good that the existing processes are there. The strengthening of our direct assignment and payment for interconnection costs by the large load customers all work together to not put us in the situation that some of the East Coast utilities have run into.
Thank you for that response. Again, I appreciate the level of detail and the scope of your response. A couple more questions for me, and that'll be it for you, Darren. Let's go back to the portion of your direct testimony that I'd quoted into the record that made reference to the desire by many, pardon me, large load customers to rely upon renewable sources of energy. Two questions in that respect. Of course, we recently had a predetermination docket whereby the commission authorized the construction of a solar facility, I believe in Douglas County, by Evergy. So as a prelude to my second question, I would ask, what additional renewable capacity are you anticipating in the near term?
Yeah, so in the near term, I don't have our most recent 2025 IRP update in front of me, but if you look over that long-term plan, we do have a slate of resources that set out there in the future beyond the commission's predetermination approvals that we just went through, and it's a mix. We have some wind additions out there in our 15-year plan. We have some solar additions out there in our 15-year plan. We have the potential for more natural gas in that plan, and we certainly have the continued expansion of demand response. And we certainly continue to evaluate, as you heard in the openings, the potential for battery storage as a solution set as well. So I'd kind of start there. We continue to look at an all above strategy. The large customers and the large customers that participated in this docket are certainly aware of our integrated resource plan and our proposals moving forward, and understand that our intention is to serve them with the capacity of the system that makes the most sense for the overall system. That said, we do have, as part of this plan in front of you for approval, 4 different renewable options Some of them are, kind of rec-based programs that sell attributes to be available for large customers. One of them is a unique plan that would allow us to work with the customer to advance an alternative proposal that might replace a preferred plan in the IRP if it is deemed available to with the large customer that's sponsoring that, helping to fund any cost differential that renewable alternative program might put on the system compared to our preferred plan. So we've tried to create some flexibility to provide options for renewable outcomes, but do it in a way that would still run through our commission processes, be it, IRP reviews and ultimately predetermination approvals, so that all stakeholders would be able to ensure that we were getting the right cost recovery to support the plan.
Thank you for that response. You actually anticipated and answered another question I had. My last question for you is simply this. What happens when this renewable wish, I'll put it that way, by either existing or prospective customers overwhelms the renewable capacity and deliverability?
Well, the first priority, as always for us, and an important part of serving these customers through our integrated system, is to ensure that we've got the reliability and resiliency on our system to serve our customers. So our foundation will continue to be, even with the load additions from the new large load customers, it'll continue to be developed through our integrated resource plan that supports those initiatives that are going to be important to all stakeholders in the commission, making sure that we've got deliverability of energy to customers, making sure we've got reliability on the system and integrity on the system. And then from there, we will look from ways that we can enhance our renewable offerings to meet some of the unique needs of not only the prospective large customers, but some of the renewable and green attribute needs that we're seeing from some of our existing communities and customers. So, but the first foundation will be doing what we're supposed to do, and that's ensuring the integrity and reliability of the system through our planning processes.
Karen, thank you very much for your responsiveness to my questions. You were responsive. I appreciate that very much. I have no further questions of this witness.
All
Thank you,
right.
Commissioner.
Thank you, Commissioner Keen. Commissioner Keither, do you have any questions for Mr. Ives?
No questions, thanks.
All right. Good morning, Mr. Ives.
Good morning, Chair.
I've got a few questions for you. Since you have the honor of going first, you get my list of questions about the settlement agreement, just walking through some terms and getting clarification, basically. So if you could pull up just the actual settlement agreement itself. Some of these questions are going to be kind of mundane, but since I didn't get the benefit of sitting through settlement negotiations, I'd just like to have your perspective and understanding some of the provisions. So if we could turn first to paragraph 21 of the settlement and let me know when you're there.
I'm there.
All right, this is on the cost stabilization rider. I just want confirmation. So this is an additional non-bypassable rider that applies when an LLPS customer is also taking service under economic development rider rates, correct?
That's correct.
And it is simply, and so it would only apply to those customers, and it is simply a mechanism to make sure that if those economic development rates were to cause the revenue you collect from them to be so low that it would have to be made up for by existing customers, that cost stabilization rider would tack on an extra amount of charge to make sure that the revenue doesn't dip too low. That's correct?
Yeah, that is correct. And if you think about it, we were in a little bit of a trick box when we were working down this path because we had some very straightforward economic development rider discounts available. And we were working in a construct where we were advancing a plan that suggested that there needed to be some cost coverage for the impact of accelerated investments that might need to be made by the utility as a result of adding these large loads. And it was inconsistent to be in a position to give a discount and then turn around and ask for some accelerated recovery. So we wanted to put a mechanism in place that said, first, you should be covering the cost to serve based on our kind of traditional system approach, and that's what the stabilization rider does. And then second, we'll address the accelerated impact or the cost to serve unique to you, and that's what under the settlement agreement that Demand Adder ended up doing. And paragraph 21 really, well, it's a little bit weirdly worded, but it was just trying not to create a circular loop where this rider would have an economic development rider, applied to when we were trying to mitigate the impact of the economic development rider. If that
Yeah.
circular reference makes sense.
I think I understand the tricky situation we were all in. It seems to me you had an option of creating this mechanism, or we all go to the legislature and ask for a legislative fix to the EDR. And this seems certainly probably the more palatable option to all the stakeholders. So I think I understand it, and it does keep the EDR option available to other customers that this might not apply to. So that does make sense to me. Okay, that's my first clarification. Paragraph 22. I want to talk briefly about the customer capacity rider. I think I understand the first part of that. It certainly sounds like it would allow for sort of a sleeved arrangement where a customer could go find a resource. You could basically procure it on their behalf and sleeve it to them. I guess the one I don't understand is farther down the paragraph where it says the company may alternatively accept replacement accredited capacity provided by the customer. Could you just explain in plain language what is meant by that?
Yeah, sure. So on the first part, I might clarify it. I really say it's not necessarily a sleeve because the way our customer capacity rider is structured is for them to have control of the capacity from the resource.
Yeah.
And bilaterally contract that to us through kind of a capacity paper purchase agreement. And then we'll use that capacity directly as part of the capacity to meet their load needs. So we won't actually take, I would say, effective ownership of the resource. It will be theirs, and we'll be contracting it from them.
Would just be paper capacity. That makes sense.
Yep.
Okay.
And then the second part is really trying to say, well, if there were an issue with that particular contracted resource, we could accept replacement accredited capacity from another resource from that customer to meet those needs. So if they for some reason lost service at that site that they had contracted with us, they could bring another resource to replace it.
Okay, so that's just sort of a backup provision that even if you initially agreed on one resource, they could swap a different one if it was acceptable to the company.
Yep, that's correct.
Okay, that makes more sense now. I'm not saying the settlement wasn't written in plain language, but this attorney sometimes needs help with legal interpretation.
Well, there's a few pages here. It's a big settlement.
Okay, next provision in paragraph 22, demand response generation rider. I understand we've got tariff provisions associated with all of these, but I'm sure you're aware that there's a lot of demand response policy changes being proposed within the Southwest Power Pool. Rather than our current policy of just letting people, count something as a simple load modifier and take it off of your resource adequacy requirement and your planning reserve margin. SPP is proposing policy revisions that would give them more insight, maybe make resources register in the marketplace and be dispatchable in the market, rather than just being part of how you manage your load behind the meter, so to speak, or behind your meter. um, how detailed is this rider, given the fact that some of those policy elements are still subject to change? Has it been written flexibly to account for that?
Yeah, so I might I might have you consider asking Mr. Lutz specifically on that. He's closer than I am. At a high level, I would tell you we have attempted to write it flexibly enough because we know, there's a lot of moving pieces and parts at SPP there. I think that's also one of the other reasons why we wanted to bring this package forward as, a set of tariff programs instead of, a set of one-off special contract negotiations with, prospective large load customers, because it does provide us all the level of flexibility to reopen and re-engage in these tariffs if we do see them starting to run inconsistent with evolutions at SPP or otherwise. That would have been a little bit tougher to do in multi-year, negotiated one-off special contracts. So that was a big part of why Evergy wanted to advance this as a tariff set of solutions.
Makes sense. I'll make a note to ask Mr. Lutz about that as well. Okay, turn all the way to paragraph 41.
I'm there.
This is on the clean energy choice rider, and this is a really interesting concept here, particularly the idea that and a customer could procure distributed energy resources, including demand side management or energy efficiency resources. And just thinking through how that would occur, are you contemplating that a customer could procure capacity or energy associated with Evergy's existing retail programs, or help Evergy fund those programs as part of this rider? Or would you see it playing out differently? It doesn't sound like this is them simply receiving credit for participating in demand response, but rather actually procuring demand response capacity. Is that correct?
Yeah, that's correct. So this one, you're right, is I would say a little bit of a unique approach with the clean energy choice rider. If you followed, across the country, Google and some folks have been involved with some clean transition riders at NV Energy and some other places where they have been able to advance alternatives for a utility to opt into some renewable resources, and those would be direct funded by the large load customer that is proposing to advance those. This is a little bit of a derivation of that. This says we want the resource to be a system-wide resource, and we want it to come through our traditional integrated resource plan process, but we might not advance it. It might not be our preferred plan. So if there is an alternative clean energy plan that the customer would propose, if it meets the needs and it runs through that stakeholder process and we all agree, then the large load customer would pay the incremental cost. If it costs more than our preferred plan, because we're supposed to be designing for
Yeah.
least cost resource plan to meet the needs, then they would cover that incremental. So when we started down the path and we started discussions, it was important as we worked with a couple of our other signatories, Sierra Club and NRDC, to add some flexibility in here for some of the provisions that you've identified. So we would actually go out and procure these distributed solar resources or this demand response as part of the solution set for the alternative plan. And to the extent that it was, maybe had a higher cost than our original preferred plan, that incremental cost for doing that would be covered by these large load customers through a line item on their bill. So it just gives us more things to look at to round out an alternative plan that could be advanced.
Okay, yeah, that all makes sense. I think, my clarification was really just on the demand response piece, and it sounds like that could come from a variety of sources. It will need to flow through the IRP, but it could be acquiring that DR capacity from an aggregator. It could be acquiring it somehow through your retail programs, if those become accredited capacity, sort of to be determined, but at the end of the day, it needs to run through the IRP to see how it all fits together.
Yep, intended to be flexible enough to create all those options, but have enough oversight through that IRP process that the stakeholders agree that it's a viable solution.
Very good. Just one quick clarification on this is on sort of all of these sort of I guess it's 4 different riders or programs under that paragraph C beginning on page 18. Just want to make sure my understanding is correct that paragraph 41, the Clean Energy Choice Rider, that would be applicable and available only to LLPS customers, but the other 3 programs, the Renew, the GSR, and the AEC, would be available to other non-residential sort of commercial and industrial customers, correct? They are not limited to just LLPS.
I believe that's correct on all 3 of those.
Okay.
Mr. Lutz will correct me when you talk to him if I misstated that, but I think that's right for all 3 of those.
All right, sounds good. All right, I do want to talk about transmission costs. Commissioner Keen got us in there quite a ways, and I think I need a couple clarifications as well, or maybe confirmation. So let's turn to paragraph 50. That seems to be the main place in the settlement where we discuss transmission costs. And there is this agreement that basically for anything built out directly for a customer, it would be directly assigned. But if transmission is identified as part of a network upgrade, through a regional planning process or through an transmission service interconnection agreement under attachment AQ, and it's base plan funded and it's network upgrade, then it wouldn't be directly assigned. It would just flow through the normal TDC and the customer would get their 12 CP share of that, correct?
That's correct.
I think this is accounted for in the settlement itself, but I want to make sure I understand. The settlement does say in the event SPP modifies cost allocation methodologies for network upgrades, that we can come back and we can change our cost allocation on the retail level, correct? So if SPP makes the decision that, and FERC approves it, that transmission service upgrades related to attachment AQ for transmission service should be directly assigned to customers of a certain size, we could come back and amend the TDC to not just spread those over a 12 CP, but to make sure that those flow through to specific customers?
That's correct. Probably not surprising to you, as we were going through the negotiations on this LLPS plan, a lot of activity going on at SPP, right? A lot of consideration of large load, a lot of consideration of, transmission backbone and a number of things in flight. And that language was intended to ensure that nobody misunderstood where we were headed, that if there were changes afoot at SPP, nobody was going to come back and assert that this negotiated agreement putting the limitations on the stakeholders or the commission on the ability to follow the cost allocation updates that would be occurring at SPP.
Yeah, and I don't mean to say that anything about current cost allocation is necessarily wrong. It's, we currently have a pretty flexible cost allocation. It is allocated based on load. So if you have a large load that comes on, then your zone gets allocated more, and then under your retail allocation, that large customer is going to bear a pretty large proportion. Not necessarily saying it needs to change. The other piece, and I don't know if this is what Commissioner Keene was alluding to, but one thing I wanted to explore is this idea that we are talking about building facilities, some directly related to interconnecting specific customers, but also we're talking about just big regional plans to address all of the large load throughout the region. And it's going to be hard to tie that to specific loads. But I think there is some concern of, what if these loads don't materialize in your region, and we're kind of stuck with it. I think I've gotten myself comfortable, but I want to walk through this, and the place I think is key here is my understanding is that TDC charges, so the amount of transmission charges that you are allocated, that Evergy is allocated from Southwest Power Pool, are part of the minimum monthly bill, which is the component, which is included in the component that would be basically committed to for a long-term contractual period, correct? So regardless of what happens with the load, if there is build out, there is a long-term revenue commitment from the retail customer to help pay for that, correct?
Yeah, the way I talk about it to folks at Evergy is everything that is a component of our bill that is not billed out on a KWH basis, so on a variable usage basis, so KW charges, which includes the TDC, comprise our minimum bill, and that the commitment at 80% of that minimum bill over the term, so the 12-year term plus the up to 5-year ramp, is really, once somebody signs an ESA, what they have committed to based upon the load that they have put into that service agreement. So it is not insignificant, by any stretch, and certainly gives us, a really good set of protections for those investments that are getting made.
Final question on transmission, and just because you just mentioned the billing by demand versus energy, there is some discussion at SPP about moving away from a pure 12 CP allocation, and perhaps looking at incorporating some element of an energy allocator, because a lot of the buildup that's occurring isn't necessarily reliability related. It is reliability related, but it's also, there is some element of, moving electrons more efficiently and giving people the benefits of accessing low-cost market energy at all times of the day. And then you have these very high load factor customers coming in and getting that benefit. And so, there is some logic in having an energy allocator to make sure that they are assigned the benefits of that big grid and the market. Not saying I'm proposing it right now, but do you believe we have the flexibility if SPP wanted to insert some component of an energy allocator, could the Evergy's TDC retail allocation be modified to reflect an energy component as well?
Yeah, so I think so I think I would suggest that there's a difference between the cost allocators that are intended to reduce to reflect the cost of serving a customer class from what your recovery choice is. So you can build an allocator to distribute cost based on a combo energy and capacity driver, but you could still recover that on a KW basis, and that KW basis would still qualify to be part of your minimum bill and part of the mechanism to ensure those protections.
So I think what you're saying is that we could do it, but that it sounds like your preference would be to always stick with a demand allocator.
Well, I think for the recovery mechanism that will make a lot of sense, but we might share the cost on a combo demand and energy basis.
I hear what you're saying. I hear what you're saying. You would look at the cost that you're allocated from the region, maybe on an energy basis, but then you would translate that into a demand charge. That makes complete sense. All right. I'm done with the settlement agreement. I just want to look, I think I have just one question about your settlement testimony. If you could turn to, I think it's page 15. Yes, it is page 15. It is your discussion of the system support rider and why that was modified into the alternative, which is a higher negotiated demand charge. And I just at a very high level, what was the objection of LLPS customers to the system support rider, and what was the benefit to them of just seeing a higher negotiated demand charge? Was it just more price certainty with the higher demand charge rather than sort of a nebulous rider, or what was the what did that discussion look like? What were the concerns raised, and what were the benefits of a demand charge?
Yeah, so thanks for the question. It was one of the areas that we probably spent some of our the highest number of hours discussing with the counterparty. So was certainly important. And I think the starting point was, what you heard in the openings. There's a lot of work going on across jurisdictions all over the country, right? And there are some things that I would say are settling into a philosophy and an approach. Some of those conditions that we talked about, a minimum term and how you structure minimum bills and things like that. You're starting to see some, I guess, some convergence on a set of those at least, even if the shape is not exactly the same. But as you start to look at what's going on the cost allocation side, that there's not as much convergence. It's been different across jurisdictions how that's been handled. And I think from the the prospective large load customers standpoint, maybe some of the other stakeholders too, while they could understand the approach that Evergy took with valuing the time value money of the acceleration of investments to serve customers, which was kind of our underpinning for that system support rider. Their articulated position, and I think you could see it in testimony in Missouri that they filed similarly, was that that's not necessarily a cost causation approach, because you're talking about future time value money stuff and it comes outside of traditional rate making parameters. So they prefer something that looks more like the traditional rate making parameters of an assignment of a demand cost. And I think the expectation is when we get customers on board, we'll be looking at some of the same things that you and I just talked about SPP looking at, on a view of an energy and a demand allocation of cost to potentially be a driver of those types of resources and investments, which I think will take us the same place where we ended up here with a demand adder, and it'll be a more traditional cost allocation approach, which I think makes customers feel a lot better in a regulatory construct.
That's really helpful. Thank you. I do have one final question, and this is going to be a summary question that I probably will ask at least one or two other witnesses, but let me preface this by saying that Google, who's on the call with us today, they've got a really good algorithm for me and my news feed, and they know what sort of things I'm interested in. And so I can tell you, when I scroll my phone every night, I get headlines all about data centers and how they are driving up retail costs for customers. And you go read those articles, and it's pretty clear quickly that those are in maybe deregulated regions that rely on capacity markets. They may have some of their details wrong. They're certainly not in this particular state, since we haven't seen anything empirical yet. They aren't certainly operating under a tariff system like what you all have proposed and what's been proposed in some other jurisdictions throughout the country. I think we don't have a lot of empirical evidence on how that plays out, but given everything right now about this tariff, it's difficult to predict what rates look like in 10, 15, 20 years, but at least for the contract term, say we have a new data center show up and sign up tomorrow under the LLPS tariff, or as soon as it's approved, if it is approved by this commission. Let's shoot big. Let's say it's a 2 gigawatt data center. Are rates for Kansas customers in that jurisdiction expected to go up within 5 to 10 years as a direct result of that data center showing up? Just as direct as I can ask it.
Yeah, so I would tell you that directly as a result of that data center showing up, I would answer that question no. Will rates go up over that 5 to 10 years? That the answer is probably yes, right? If we think about just what our plan is in general that's in front of us, and our need to kind of manage the system holistically and put investment on to serve and be reliable, I think we foresee rate pressures, and as we've talked in other forums in both Kansas and Missouri, we've got a lot of work in front of us to balance affordability and reliability. What we have done with this set of tariffs, in my opinion, is we have taken our best first step to make sure that we are adequately getting a recovery of costs from these large customers to ensure that we aren't creating those unintended consequences on existing customers and can give the existing customers an opportunity to benefit from bringing in the type of load that these guys would bring onto the system. Now, do we have it 100% right? I wouldn't argue that because we don't have a customer in the state yet, and we're working on assumptions and solving to meet assumptions. But that's why it was so important to us to do two things. One, put it in a flexible but tariffed program that all the stakeholders would be a part of developing. And we spent as many hours as we did in this unique process because it was important to get the input from all the parties that are a part of this docket to get us started. And then it's important from there to have the input from all these parties each time we reevaluate these tariffs when we have cases to make sure they're still doing what we intend them to do, that they're getting the right recovery for the right costs that are being incurred. And if not, we'll all have to work it out in the next rate case and then the one after that as we learn and get better visibility and better information.
All right, thank you, Mr. Ives. I think that answers all my questions for now. Let me see if either of the other commissioners developed any additional questions since I took some time with you there. Commissioner Keen or Commissioner Keither?
No, thank you, Chair French.
All right. With that, then, Ms. Dingus, do you have any redirect?
No redirect. Thank you.
All right, thank you. Well, since there's no redirect and no further commissioner questions, Mr. Ives, you may step down. We thank you for your testimony today.
Thank you, Chair. Thank you, Commissioners.
Why don't we, I know we're in the middle of your witnesses, Ms. Dingus, but we've been going for about an hour and a half. We're mid-morning now. Let's give everybody let's do an 8-minute break because I've got 10:32. Let's do a short break and we'll just come back at 10:40 and reconvene. So we are off the record and we will reconvene at 10:40. All right, I have 1040. Michelle, you can drop the slide. Thank you. Okay, we're at 1040, so we are now back on the record in the evidentiary hearing for docket number 25, EKME 315 TAR. We are ready for Evergy to call its second witness. Ms. Dingus, you may proceed.
Good morning, and I'm actually going to
Ms.
call,
Shields.
yes, I'm going to call Mr. Brad Lutz to the virtual stand. Mr. Lutz, if you could please state your name and title for the record.
My name is... Before we begin, let's have Mr. Lutz raise his right hand and be sworn.
All right. Mr. Lutz, do you swear that the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Counsel, your witness.
Great. And again, if you could please state your name and title for the record.
My name is Brad Lutz. I'm a Director of Regulatory Affairs.
Great. Mr. Lutz, you are the same Mr. Lutz who filed direct testimony and settlement testimony in this proceeding, correct?
I am.
Great. And that has been moved into the record. So with that, the witness is available for commissioner questions.
All right, thank you. We will begin with Commissioner Keene again, if you have questions for this witness.
Yes, thank you, Chair French. Good morning, Mr. Lutz.
Good morning, sir.
Mr. Lutz, I have reserved most of my settlement agreement questions for you.
Okay.
And the reason I've done that is that on page 19 of the settlement agreement at page 45, it makes specific reference to your direct testimony and to me, in effect, incorporates by reference your testimony into the settlement agreement in part. Just by way of overview and to disclose about the only bias I have in approaching these matters, for me, the allocation of costs among the various rate classes, including this new rate class, is a major concern and matter of interest. The allocation of costs to reflect the actual benefits among the various rate classes, to me, is the most consequential consideration, especially in protecting the two most vulnerable rate classes, I think, in terms of affordability, and that is residential, retail, and the small business rate classes. All right, having said that, if we could, I think what I will do is kind of break my questions into two general parts, Mr. Lutz. One, as we work through, not many, but just a few parts of the settlement agreement, and then do some backfilling with regard to your direct testimony. So if we turn to the settlement agreement first, my first question, I don't think we need to do any screen sharing on this whatsoever. I'll pretty much treat my questions here in an analogous fashion to what Chair French did with Mr. Ives. Give you a chance to take a look at what I'm referring to. My first question has to do with paragraph 18 on page 9 under the heading interim capacity adjustment. Okay. Let me read just a portion of your testimony here. Pardon me, a portion of the settlement agreement here by way of background, and then ask a rather specific question. The settlement agreement says, if the company determines, and I'm going to try to cut to the chase here and not read exactly every word in this paragraph, but capture the essence. If the company determines that the customer's load cannot be served by the company's existing system capabilities, the company may enter into specific market contract agreements to provide the necessary capacity requirements of the customer until sufficient system capacity may be supplied by the company. The customer and the company must mutually agree upon the terms for the interim capacity procured by the company. It goes on to say, the customer shall be subject to an additional demand charge, and it says how that's to be calculated, with the customer responsible for it says full costs thereof. My question to you is, what does that mean in your view? And how is that full cost thereof determined so that it protects other ratepayers and other rate classes?
Yes, the entire basis of this provision is to provide us some flexibility in achieving the timing of needed loads. And as I'm sure you can understand, the provision of capacity to serve a resource is the constraint often for actually providing service to these customers. So should we not be positioned as the utility to have that capacity ready when a customer might want it, and we're able to find capacity on the market, this provision would allow us to bring that to bear as kind of a stopgap or transitional measure until we're ready with our own resources. Now, to focus on your point there, it's our expectation that this will be executed through a distinct capacity agreement. And that execution of that agreement will establish the cost. So, it needs to be delivered to our SPP load node so that it can be brought to bear for service to this customer. So should there need to be some kind of cost of delivery, that would have to be part of that. And all of those terms will be laid out in that agreement and would establish the cost that customer solely will pay for that capacity for that interim duration.
Okay, that's helpful. That adds some that adds some background information that's very helpful there. Thank you for that. Let's take a look next at, if we could, at paragraph 44. This is the AEC, or the Alternative Credit Rider.
Yes, sir.
And as a follow-on to some of the questions that the chair had directed to Mr. Ives, I believe, if I understood one of Mr. Ives' responses to those questions, was that that this particular rider is available to all customers. Is that correct? Not just the new class, but to all customers?
That is correct.
Okay. Again, let me read here a bit from that very short paragraph. It says that this will provide large customers with the ability to include emission-free nuclear energy from company-owned or sourced resources into their clean energy portfolio to support the customer's sustainability and decarbonization goals. So my question to you is kind of analogous to one I asked of Mr. Ives, and that is, how does this rider here potentially impact these energy resources and their availability to non-LLRS customers?
Yes. Now this one's unique, maybe in my opinion, with it being more focused on carbon-free, which is kind of a distinct class of renewable credits. If you follow this area, the more common has been those renewable energy credits associated with wind or solar resources that are defined as a certain type of sustainable or green resource, where this is a different category, being carbon free. Some companies don't recognize carbon free in the same way they recognize sustainable sources, say like wind or solar. So it's really dependent on the need of the individual customer and whether they recognize carbon free as being an acceptable means of achieving their sustainability goals. So in our experiences, this has often been more governmental or larger customers that have been interested in this. And that's why you've not seen this broadly offered until now. Many of our smaller customers, most customers that we've seen before large load, were served under the traditional renewable energy credit programs that we had, like Renew, for example. But this expands that. So it really is going to be driven by customer need and the ability to rely on carbon-free attributes to meet their prospective sustainability goals.
Okay. Let's move on to paragraph 50 on page 20.
Okay.
This is under the caption of rules and regulations.
Yes, sir.
And let me again read a portion of this and then ask a question. It says the signatories agree to the addition of language to section 8 of the company's general rules and regulations that extensions of transmission or substation facilities, any customer service with substation or transmission facilities shall pay, it says, all costs associated with such extensions. And it goes on to say these costs will not include any resulting network upgrade costs for facilities classified as transmission under the Southwest Power Pool Open Access Transmission Tariff.
Yes, sir.
My question to you, first question is, when it refers to that the customer requesting service shall pay all costs, what is included within the purview of all costs? And more to the point, what is not included in your judgment?
Well, as far as what is included, let me go there first. What that would be all of the physical assets, poles, wires, conduits, equipment, devices necessary to interconnect that customer to the grid. The direct interconnected ones are the ones that have not been deemed part of the network by SPP. And so that's the real division between the costs. But it would reflect all of the materials, the installations, any of the overheads applied to those would be all inclusive in those costs. And the only differentiation would be whether it deemed a network element or a direct connect. And anything that falls in the direct connect category would be paid by that customer.
What about the other category then? The flip side of the question is, within the purview of this phrase, all costs, what is not included?
Yeah, as far as what's not included, that's a harder question to answer. Maybe I'll say it this way, and maybe this is where the question is leading, but those costs that are deemed part of the network by SPP and flow through the SPP open access tariff, this is a reference back to what Darren Ives was mentioning about how that would then flow through the SPP tariffs and would be allocated to all SPP members through those processes. And those costs would be addressed in that manner. So maybe that is what's not addressed by the direct. Am I giving you the answer you're?
I think you're trying to. No question about that. It is a difficult question because I think it's probably difficult to answer it with absolutely no ambiguity. That's the difficulty of it.
Right.
And therein kind of lies the rub, because we talk about at the real point of inflection, who does bear which portions of those kinds of costs. That's a concern.
Right. And if you'll allow me this, I mean, all of the costs of construction, all of those incremental costs that we're incurring to do the work are captured. Then it's just a matter of which bucket do they fall in, whether they fall under the SPP responsibility or the direct customer. So, the SPP process is key in this determination. So we will continue to follow. And I think Chair French asked a question that offered a scenario where SPP changes the process. We will follow. SPP will be the measure, and if they choose to approach this differently, we will follow that and apply those costs according to their lead.
All right. Thank you for that response. Let's turn within the purview of the settlement agreement last for my set of questions to page 27, if you would. On page 27 is Exhibit A, which is a schedule that shows the LLPS initial monthly pricing. If I can ask you a couple of holistic questions, and then we'll kind of drill down maybe a little bit. Again, as a point of reference for the commission and for anybody looking in who has not had the chance to read the settlement agreement, I guess my question to you, Brad, would be generally how are these different pricing elements different from the charges and rates that would exist in the absence of LLPS pricing?
Okay. Structurally, let's start there. Structurally, these elements are identical to what we do within our ILP or LLPS classes. I mentioned both of those because Kansas Central is termed the ILP rate schedule and Kansas Metro the LPS. But for all intents and purposes, we can treat them the same for this discussion. But these charge elements noted in the leftmost column are common to those existing rate schedules. So I would say they would be identical. What's different is the pricing. And what we've done, and my direct testimony speaks to this a little bit, is that we took some steps to what I would say better align those costs with their category of description. So, for example, energy costs have been modified to try to isolate only energy-related costs, and demand have been modified to only affect demand-related costs. And the reason why that's important or notable is that our existing rates have a certain amount of commingling of those costs. It's not perfectly aligned with cost of service. And that occurs for a multiple number of valid reasons. So it's not that it's necessarily wrong, but for our situation here under large load, we wanted to have that alignment as clean as possible because we had other elements of the large load plan, like interim capacity or the customer capacity rider, that were bringing capacity costs into the equation. So if we had everything priced as perfectly as we could, then the gives and takes that would occur through those riders would be better managed and be more accurate. So the pricing here is different in that respect. Now, what I would conclude in saying is that if you view these rates and you compare them to the existing large load rates on a simple average cents per kilowatt hour basis, there is a relationship. And what we did is we designed our rates such that they provided a higher average cost or average cents per kilowatt hour rate to large load customers than they would have received had they received service under the ILP or LPS class. So these rates are a little bit of a premium, I guess is what I would say, to what they might see under the existing large power or industrial large power rates. So there's a lot of relationship, but the pricing is distinct and reflects what we needed for the large load customer group.
Thank you very much. The granularity of that answer was very helpful. I appreciate your doing that. The next question I'm going to ask, you actually answered it within the purview of your last answer, but the audio, as I'm receiving, cut out, so that I didn't really hear you say that. It's generally your audio is good. It just at that particular point it cut out, and it wasn't a screen freeze, but it just cut out. So I'm going to ask you this question. It's a bit repetitive, but at least maybe we can have you clarify it one more time. Why are the charges here different for Evergy Central versus Evergy Metro?
Yeah, now that point is fair. I did not make that distinction, but what this represents is just the difference in the underlying costs for those two utilities. They have a different cost basis, whether that be made up of the production resources that are in those jurisdictions or simply the other costs that flow through the other accounts. But it's just the difference in the jurisdictional costs that reflect the difference you see here.
Fair enough. looking at the schedule that you have here,
Mhm.
given the backdrop of the explanation you have for how it varies from other large load pricing, were it not for this schedule. Let me ask you this somewhat holistically now, just very open-ended. So what, in your judgment, is the impact of this LLPS tariff on other ratepayer classes in terms of cost sharing?
Okay. Well, let me first say that I cannot ignore the detail around the protections. That the complete set of protections that are included in the large load schedule are extremely helpful in avoiding future costs or future issues. It helps protect, it helps make sure that we're getting customers that are serious about being here. We've got customers that are willing to enter into long-term commitments to stay customers with us and see through all of the efforts it'll take to provide service to these customers. So those protections are fundamental and necessary for the successful large load, especially in that frame of view around cost causation and making sure that they're contributing. The other part of this is I do believe that this rate, as I mentioned, is designed to be a premium on that service as compared to the current large load tariffs. And that will be instrumental in how we will deal with cost causation going forward in our future cost of service studies, future rate cases. We will be relying on that difference to help us make sure that we're covering the effects on any other customer classes as we continue to grow together in this shared system.
Again, I appreciate the detail of your answer. It was a good answer, I think.
Yeah.
Within the context of these customer protections, which are really central to, it's one of the central aspects, certainly, of the whole proposal. If we could screen share what is basically page 7 of the slide presentations that Ms. Shields began our morning with.
Ms. Shields, if you're able to share that, that would be great.
Yes.
I'm guessing you have it closer at hand than anyone else.
Yes, and I'm hearing page 7.
Yes, please.
Great.
I have it as well, Caitlin, if you.
Great. I think here we go.
That's it.
Yep.
Thank you. Thank you. Yep, we lost it. Okay.
Mm-hmm.
It appears to be up there until it went.
Okay, I think we're back.
Looks good to me.
Okay.
Just a question quickly before it goes away. No. Mr. Lutz, does this generally capture the essence of the customer protections to which you were making reference?
Yes, sir.
Realizing that each one of these customer protections tries to satisfy a different goal or requirement. They're intended to work collectively. They're intended to each one assist the other.
Yes.
In terms of impact, from your perspective and from your experience, which of these do you, in relative terms, do you consider to be the most consequential in terms of trying to be competitive as Evergy is trying to do, while simultaneously protecting customers?
I think it's the collateral requirements and credit standards, in my opinion. The other provisions often exist in some form or another. These are certainly stronger than many of the minimum bill or demand charge provisions we have currently within our rates. But I think it's the collateral requirements and credit standards that stands apart. This is designed to address just the month-to-month exposure that we have to customers that are consuming, large amounts of energy from us, and therefore have very high bills month to month. And this will establish a protection to make sure that we know these customers are going to be able to basically pay their bill, stay current throughout time. And these provisions, if they're set too strong and require too much from a customer, it could make us competitively less strong to another jurisdiction that maybe, frankly, is more willing to expose themselves to that risk. That being said, we've been very diligent to stay alert to what's going on in the industry. And I certainly point out to the feedback and work that happened with the Data Center Coalition to refine the terms that we've settled on for the collateral requirements, to put forward a very balanced approach that should put us in a pretty fair competitive position. I always joke about this a little bit, but Darren Ives has used the middle of the fairway phrase many times to describe our goal. And this meets that. It feels to me that we've placed the ball in the middle of the fairway. There are going to be people that are going to be more stringent, and there's going to be people more liberal than us in this category. But for our jurisdiction and for the customers that we serve, we feel like we've made a good tee shot.
Again, I appreciate the frankness and the directness of the response. It's really quite helpful. You pretty much answered the second part of that question, which had to do with within the context again of these protections, which do you believe are the most consequential in providing Evergy with competitiveness, especially in the arena of economic development? If you care to embellish that a little bit, please do.
Well, I would only go further to say that the settlement in its entirety, I think, has done that. I've been very pleased and impressed with the work that the group did to balance all of the varying views and come in with a total package that addresses and checks many of the boxes that we see in other jurisdictions, while putting forward a structure that can kind of grow with us as we gain more knowledge, we gain customers, as stakeholders become more comfortable, responding to large loads and incorporating them in our collective processes. So I think it's the entire settlement, not any one of these protections, but the combination of all of the elements that work together to put us in a very favorable place. I look to the Data Center Coalition and Google as examples of that. I think that their experience has been fundamentally important to getting this right. And we've listened. I mean, I'll just say it plainly. We've not tried to be bullheaded or obstinate about this, but we've listened. I know staff, Curb, have also listened, and there's just a lot of balance that can be found in this settlement.
Very well. Before we turn away from this slide we're sharing here, under rate design, if I understand it, the LLPS customers will provide affirmative rate benefits to non-participants by paying, basically, it's the demand charge above the embedded cost to serve. Am I correct in adding that in within the purview of what's meant there?
You are correct. That is the key element of the rate design. You bet.
Okay. If we could take down the screen share, please. The last series of questions, Mr. Lutz, and there aren't many in number, or pertain back to your direct testimony. So if we can take a look at that. My first question appears on, I think it's on page 64 of your direct testimony.
I've got a lot of pages, don't I?
You have. You've added a lot to the record. Thank you for that.
I get paid by the word.
I was wondering if you did. I'm sure you're underpaid if you worked.
I'll talk to Darren after the hearing.
We're under the category here in terms of the subject matter of large load customer benefits. That's the general topic.
Yes.
And I'm going to kind of pick and choose what I lift from your presentation here. If I do it in injustice before I ask the question, please don't hesitate to correct me. But in essence, what you're saying here is that adding new large load customers will be beneficial to all customers in the state of Kansas, that there will be rate making benefits as well. And you go on to say, as additional customers are added to the system and our retail customer load, this will increase the amount of energy consumed, enabling the company to spread the fixed costs of utility service over more kilowatt hours, in return reducing the average cost for all customers. You go on to finish that thought by saying the key to making this successful is adding customers at an average or above average cost to serve. To what extent do you see these savings that you believe will accrue to all customers? To what extent do you see that being realized? Is it being realized through relatively smaller future rate increases, or by what other mechanism do you see that being realized?
Yeah, I think that's fair. I think the variables here are any kind of resource changes that are also required. If you use those classic economic tools like, was it ceteris paribus, where you hold everything else equal, then that's where some of this math works, for sure. But even still, as we add resources, the inclusion of large customers and their billing determinants, the kilowatt hours and kW that they introduce to the math of rate making, will further distribute costs. So I think it's most accurate to say, as you did, that it's probably going to be realized in reductions of increases in the future. I think it's difficult to avoid increases, in the state that we're in, with capacity and the need to grow and respond to changes at SPP. But I think those can be lessened in effect because of that sharing effect that occurs when a large load customer joins the system.
Okay, very good. My last question arises from your direct testimony responses on page 68 in the conclusion.
Okay.
Again, Brad, with your indulgence here, if I may kind of pick and choose what I'm lifting from your direct testimony, beginning on line 12. It says the company has conducted a thorough and diligent process to develop tariffs and rate design approaches that will attract and retain large customers while protecting non-participants from undue risk. It goes on to say a couple of sentences down, applicable to customers with loads greater than 100,000 megawatts, the schedule LLPS tariff lays out a pricing structure combined with key protections such as, and you list what those are. Mm-hmm. It says the design also incorporates provisions for interim capacity and contract capacity adjustments, features that would improve flexibility for customers, facilitate speed to market, and avoid, this is the key part for me, potential undue cross subsidization, easy for me to say. Yes. Explain what that means. What do you mean by avoiding undue cross subsidization?
Right. And those are focused mainly on the interim capacity and contract capacity rider and those adjustments. Those, if you recall the design, those are dollar for dollar pass-throughs of those costs directly to the large load customers that are benefiting from those. So that's where the the cross subsidization, now I'm doing it, is eliminated, because then that cost is paid for by the customer. You can roll back to some degree and apply these to other provisions of the rate designs. We've talked about that a little bit, but the key cross subsidization avoidance mechanisms are those two capacity provisions that link those capacity costs directly to the customer that's using those.
Very helpful. Brad, thank you so much for your indulgence in my questions. Your responses have been you've been most responsive throughout. I'm grateful for it. You've added certainly to my knowledge about what's happening here, and I thank you very much. I have no further questions of this witness, Mr. Chair.
All right. Thank you, Commissioner Keene. Commissioner Keither, do you have any questions for Mr. Lutz?
I don't. I appreciate Commissioner Keene's questions. They were in areas that I had. Thank you.
And I had no questions for you, Mr. Lutz. Mr. Ives tried to throw you to me, but I feel like I got what I needed out of his answers. I would just offer you the opportunity. There were a couple answers where he specifically referred to you. I don't know if you wrote down any notes of anything you wanted to add on either the demand response tariff or on my discussion with him of SPP transmission costs and how our flexibility to change. If there was anything you wanted to add on either of those, I feel like he answered it, but I would offer you the opportunity to add.
Yeah, thank you. I think the only thing I might do is just reinforce that with respect to the demand response rider. Certainly, I acknowledge, and we acknowledge corporately, that that's a moving target. But certainly the theme and what you heard from Mr. Ives about the ability to adjust and align is front of mind. That is why we're doing it this way. This allows us to I don't want to say pivot, because that often has a negative connotation, but instead just to stay aligned as this grows, as we get smarter, as SPP makes policy changes, including the area of demand response. We will follow, we will stay aligned, and I think that's the benefit of the structure that we've proposed.
Yeah, that's helpful. Yeah, I have votes on some of those things at SPP, and I don't necessarily have my position formulated, but it is a concern as you all have to respond with a tariff that is going to take you some time to prepare, and then can take as long as 240 days for the KCC to process and approve. That flexibility sometimes is difficult when SPP is setting policy and incorporating it into their market rules and their resource adequacy rules. Glad to hear at the very least that we have the same concern and same considerations. So
yes, sir.
We'll very much be looking forward to that. So appreciate the additional response. Ms. Shields, do you have any redirect for your witness?
No, I have no redirect. Thank you.
All right, thank you. Mr. Lutz, we appreciate your testimony. At this time, you may step down.
Thank you.
Virtually. Thank you. All right, with that, I believe we will proceed in order, and I believe the commissioners indicated they did not wish to release Mr. Gorman. So, Mr. Zakura, you may call your witness.
Thank you. The industrial consumers call to the witness stand Mr. Mike Gorman.
Mr. Gorman, if you would please raise your right hand, I'll have the court reporter swear you in.
Right. Mr. Gorman, do you swear that the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
May I proceed?
Yes, please proceed, Mr. Zakura.
Good morning, Mr. Gorman. Are you the same Mike Gorman that filed direct testimony in this case and also testimony in support of the settlement?
Yes.
And your testimony is filed on behalf of the industrial consumers, the Kansas Industrial Consumers Group. Is that correct, sir?
It is correct, yes.
Is the testimony that you filed in this case, does it remain true and correct in every fashion?
Yeah, it does, yes.
And there are no amendments to that testimony at this time?
I'm not aware of any need for amendments. That's correct.
With that, I would tender the witness for examination by the commissioners.
All right, thank you, Mr. Sakura. Keeping with our same order, I will turn first to Commissioner Keen for any questions.
Thank you, Chair French. Good morning, Mr. Gorman.
Good morning.
I believe I'm the one responsible for holding you over, and I'll tell you, I always look forward to your testimony, to be very frank. I believe your testimony is consistently thought-provoking and very evocative, and I had a major overview question I wanted to ask you, and now is the time. I'm looking basically, I'm looking at your testimony, and this would be your settlement testimony, Mr. Gorman, and on page 3.
Okay.
It's fairly short. Your testimony is fairly short, but let me, if you can indulge me as the previous witnesses have, if I can basically paraphrase a little bit what. Well, I'll just read it. Let me read the question and the answer. It's encompassed within lines 1 through 7. I'm going to read 1 through 5. The question is, why should the commission approve the unanimous settlement agreement? Your answer is that the settlement agreement represents a negotiated settlement of the tariff terms and prices for LLPS customers that is designed along with service agreement that it provides Evergy reasonable assurance of recovering its cost to provide service to a LLPS customer. And what's of critical concern to me is your conclusion, and to do so without creating negative impacts on remaining Evergy customers. I'm going to give you quite a license here to respond. My question to you is, how does it do that? How does it both provide an effective cost recovery mechanism for the company, and more to the point, how does it do so without creating any negative impacts to other Evergy customers?
Thank you for the comments, Commissioner. And my belief is that the pricing structure for the LLPS customers will allow Evergy to recover its embedded cost of serving that customer, along with incremental cost associated with specific capacity additions, that ensure that this customer that an LLPS customer will pay rates that recover more than the embedded cost of service. From that standpoint, I believe it allows for the recovery of prudent and reasonable costs to all customers, as well as certain administrative costs which the utility can incur from time to time that would be spread amongst all customers within the embedded cost of service structure that may relate to items that provide the utility whole for prudently incurred costs, but aren't necessarily continuing costs associated with providing service. Examples of those could include early retirement of coal-fired units, Storm Uri cost, and other weather-related storm costs, which resulted in costs the utility is allowed to recover from customers that pay embedded cost rates, but are not specifically related to the provision of providing service currently. In addition to that, it also has an incremental cost in pricing in LLPS customers' rates. From that standpoint, I believe other customers are protected in that the LLPS customer will pay the incremental cost of service, something above embedded cost of service, including those extraneous costs which may be included in the utility's revenue requirement. as well as was the incremental an item that relates to the incremental cost of providing service from Evergy.
Okay. I appreciate that. That was inclusive and succinct. So it would be your conclusion then, I believe, if I'm reading between the lines here, that the cost allocation and sharing provisions, in your judgment, as reflected in the settlement agreement, would be fair to basically all customer classes?
Based on what we know at this point, yes. And within each rate case, if new issues come up or arise, they can be addressed in those rate cases. But based on this structure, I believe that all customers are treated fairly, including the LLPS customers.
Very good. Pardon my talking over you there briefly. I appreciate the response. Thank you very much, Mr. Gorman. I have no further questions of this witness.
All right, Commissioner Keither, any questions? Well, I see a shaking head. Mr. Gorman, I said I wasn't going to have questions, but since Commissioner Keene drug you up here, I am I am going to take the opportunity to draw on your experience. Mr. Zakura mentioned that you and your firm are, pretty engaged across the country looking at these types of tariffs as they are beginning to pop up, and certainly there are a lot of consistent elements across the different utilities in how they are dealing with this, but there are also some unique elements in this plan and then in some others I've seen. Could I just lean on your experience and looking across the different tariff options you've seen? Is there anything that you would find notable about this particular proposal? Is it very consistent? Are there any aspects that you think we are doing better than other jurisdictions? Any aspects that you think that we're deficient compared to other jurisdictions? If you could just give me any brief thoughts as a comparison across other jurisdictions.
I think this contract provides the same sort of financial assurances to the utility that large customer loads will be responsible for the cost of serving those customers. I think this agreement is somewhat notable in that it allows data centers to bring capacity to serve their load through the utility. I know that aspect of this agreement is getting a lot of attention outside of Kansas. And the credit assurances included in the contract provide an acceptable range of credit assurances, which is also an element that is getting a lot of attention in similar tariffs outside of Kansas, and the flexibility, but the reliability of the financial support for this large LLPS customer tariff contract is also, I think, well thought out and supportive of protecting both Evergy and existing customers.
Thank you for that. Yeah, my review of some other tariffs and this one, I also noted that the section on creditworthiness requirements and collateral requirements is quite a bit longer under this tariff and settlement than some others I'd viewed, and I think, to your point, it provides a range of different options, more than maybe you've seen in others. So that is interesting. Well, I believe that is only the only question I had. I wasn't going to forgo the opportunity once we get you up here to get your perspective from a national perspective. So thank you very much. I have no further questions. If there are no further commissioner questions, Mr. Zakura, any need for redirect?
No redirect. Thank you.
All right, Mr. Gorman, you may step down virtually.
Thank you. Appreciate it.
All right, we will move to the Data Center Coalition. Ms. Greenwald, you may call your witness.
Thank you. DCC calls Kevin Higgins.
All right, Mr. Higgins, I think your name is showing up as Ms. Greenwald, but we're going to assume it's Mr. Higgins. Maybe somebody on our IT staff can rename you. I think they have that capability. Would you please raise your right hand?
Mr. Higgins, do you swear that the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Great. Chair French, your witness.
All right. Ms. Greenwald, you may proceed.
Thank you. All right, please state your name for the record.
My name is Kevin C. Higgins.
And by whom are you employed and in what capacity?
I'm a principal in the consulting firm Evergy Strategies.
On whose behalf do you offer testimony in this proceeding?
I'm here on behalf of the Data Center Coalition.
And did you prepare and cause to be filed the settlement testimony of Kevin Higgins on September 5th, 2025?
Yes.
And that testimony has previously been admitted into the record?
Yes.
If you were to give the same testimony live today, would your answers be substantially similar?
Yes.
Okay, I tender the witness for commission questions.
All right, thank you. We will keep with the same order, and I will begin with Commissioner Keene.
Thank you. Good morning, Mr. Higgins.
Good morning, Commissioner Keene.
Mr. Higgins, I've read through your settlement testimony, coupled with the opening overview that was provided by Ms. Greenwald. I think I have a pretty good idea about where your position is and where you're coming from. Accordingly, I have no questions. Thank you for your appearance here this morning, however.
Thank you.
Commissioner Keither, any questions?
No question, thanks.
All right. Well, I want to give you the opportunity to to answer something, Mr. Higgins. So I agree. I think I have a pretty good view of your position, but the piece that is a little intriguing to me, and I just want to hear directly from you, and I'm probably going to ask the witness from Google the same question, is this settlement and tariff is very much geared around protections for existing customers, and understandably so. And it even includes sort of, as we've heard described, premium pricing for, the sort of an extraordinary service request, but I guess I would like your perspective. Could you elaborate on why getting a tariff like this in place is actually not going to push away customers, but is actually attractive for large load customers? Or is it attractive? I'm assuming that based on the fact that you're a signatory. Why is it attractive? Is it just the fact that there is now a structure in place and there is certainty related to pricing, or is there anything specific about this program and tariff that does now make this an attractive offering for the Data Center Coalition and its members?
Thank you for that question, Chair French. To begin with, when I first started providing testimony on behalf of the Data Center Coalition, that was in the AEP Ohio case, and subsequently participated in the I&M case in Indiana, as well as in the Evergy, Missouri case, and as well the Dominion Biennial Review in Virginia. And the going in principles that the Data Center Coalition adopted with my full concurrence is that the Data Center Coalition members are not looking for below cost rates. They acknowledge the challenges that utilities and regulators are facing in coping with the new increase in load requests. And so a going forward principle was to acknowledge those challenges and to support the development of terms and conditions in rates that would provide the assurances necessary to not just the utilities, but to the regulators, that the investments that were being made on behalf of supporting growth would be supported by long-term contracts with minimum demand requirements and supported by reasonable collateral requirements. And so when you ask about, why is this attractive? From the get-go, the data center coalitions believed that the kinds of ingredients that are included in this settlement agreement are necessary to allow investment in data centers to go forward throughout the country with reasonable regulatory assurances that we believe are needed to support the growth. As to the pricing terms, you are correct that it provides some pricing certainty. And even though the rates are admittedly at a premium, the Data Center Coalition agreed to these terms, to support these terms, because we felt it was still within a reasonable range, and that it, combined with the rate certainty, combined with the underlying cost of service in the Evergy service territory, that despite the fact that the rates are at a premium relative to the otherwise available rates, it represented a reasonable compromise and a reasonable package when you take into account all of the other many important terms that are included in the settlement agreement.
Thank you for that answer, Mr. Higgins. That is kind of exactly the context I was looking to understand. So that was really my only question for you. So unless that has elicited anything else from the other two commissioners, oh, Commissioner Keene's got his hand waving here. Commissioner Keene, do you have a follow-up question?
Yes, if I could, kind of a follow-on.
Go for it.
I don't mean to be repetitive at all, Mr. Higgins, but we have the benefit of your knowledge about the diversity of these kinds of circumstances, these kinds of agreements across the country. I don't mean this to be a Fifth Amendment question, but you could certainly take that if you would. In terms of the competitiveness of or any competitive advantages this may afford the company vis-a-vis other states, how do you view that?
Commissioner Keene, I haven't, done a head-to-head comparison, pardon me, of all the rates available throughout the rest of the country. But, I do believe that, based on my experience in rate making, that the Evergy underlying rates are reasonably competitive viewed at a national level. So I don't have a specific matrix designed to calculate that, but I do believe they are reasonably in the ballpark when especially then when you take into account the structure of the protections and the assurances that are included in the settlement agreement.
Very good. Thank you for that response. No other questions.
All right, thank you. Ms. Greenwald, any need for redirect?
No redirect questions. Thank you.
All right. Mr. Higgins, we do thank you for your testimony today, and you may virtually step down.
Thank you.
All right. Counsel for Google, Mr. Cairo, you may call your witness.
Thank you, Chair French. On behalf of Google, we call Dr. Carolyn Berry.
All right, Ms. Berry, will you please raise your right hand so the court reporter may swear you in?
Ms. Berry, do you swear that the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. Counsel, your witness.
Thank you. Would you please state your name and business address for the record?
My name is Carolyn A. Berry, and my business address is 2001 K Street Northwest, North Building, Suite 500, Washington, D.C. 20006.
And who are you employed by?
Bates White Economic Consulting.
Ms. Berry, are you the same Dr. Berry who caused to be pre-filed testimony in support of the unanimous settlement agreement before the commission in this docket on September 5th?
Yes, I am.
2025? Yes.
Yes, I am. Sorry about that.
Thank you. And since that testimony's been stipulated into the record, Dr. Berry, I will tender you for cross-examination or questions by the commissioners. Thank you.
All right, thank you, Mr. Cairo. Again, we will turn to Commissioner Keen first, if you have any questions of this witness.
Yes, can you hear me?
Yes, we do.
My screen tried to do something very weird there. Hang on a second. All right, it's back. Good morning, Dr. Berry.
Good morning.
It's still morning, but barely so. Where you are, it's not. It's afternoon. So, anyway, have you been present this morning to hear the testimony of the witnesses prior to your testimony?
Yes.
If I could, I want to harken back to the questions I asked the last witness, Mr. Higgins. Given what I have read your testimony, Dr. Berry, and when I couple that with the overview that Mr. Cairo provided, I think I have a pretty good sense about where you're coming from here. But the question I would ask, basically, of you is the same one of Mr. Higgins. Dr. Berry, I'm not asking you to provide anything more than basically your judgment based upon what's going to be a very general question I'm directing to you in terms of given the terms, the protections that are contained within the settlement agreement, the other matters that have to do with trying to provide protections to the company as well, and within a context of competitiveness among the states and among other utilities that would be offering analogous terms or procedures. How competitive do you believe the essence of what the settlement agreement provides for is going to be?
So looking out across, of course, looking across the country at the various tariffs in place, a lot of them reflect, the structures of their markets. I'll give you an example. For example, in Virginia, which is sort of the ground zero for data centers, it's got a different market structure out there. Of course, they're in PJM, and they have, for example, different demand charges or minimum demand charges for transmission than they have for distribution and capacity. So, for example, those are more tailored, and they have different concerns out there. So you get a different package of attributes in these tariffs. I think that the tariff in Kansas is very similar to that for Indiana, that was approved for Indiana, Michigan Power. And that the circumstances there are more closely aligned. And then Missouri, I think, the proposal there is very, very similar to what's in Kansas. Overall, I would say yes, that it's very competitive. I think that you've got some outliers. You've got, for example, Kentucky has a 90% minimum demand charge, different package of things. You really have to evaluate by the whole package to kind of get a good sense for how comparable it is. But they also have, different sets of customers too. And I think also people are at different places in their development of large load. So since Kansas is at the beginning and doesn't have large load yet, there are sort of issues that still need to be, learned with experience. So overall, in terms of, sort of competitiveness of their appeal, I think it's right. It hits the mark right in the middle. I think it's very competitive, and it provides, the security, well, it provides a firm footing for for Google that wants to come in. They've got, not only do they have certain terms, but they have, they've got a relationship now that I think that they can build on in the future. They've got mutual understanding. I think that's really critical. They might not have that so much in other states. And that's due to the process that Evergy put in place with these workshops, which were tremendously helpful and really, I think, created that trust between parties.
Thank you very much. That was a great overview answer, and I appreciate the granularity of your answer as well. I have no further questions.
All right, Commissioner Keither, any questions of this witness?
No questions, thanks.
Well, I was going to ask you a very similar question to what Commissioner Keene asked, and you provide a comprehensive response. So I don't think I'm gonna be redundant, Ms. Berry. I do appreciate you being here virtually and offering your testimony, and appreciate you entering written testimony in this proceeding. So with that, I will turn to Mr. Cairo. Mr. Cairo, any need for redirect?
No redirect, thank you.
All right. Well, with that, Ms. Berry, you may virtually step down.
Thank you, Commissioner.
All right. I believe all of the commissioners indicated they did not have questions for Curb's witness, Mr. France. So we will move to our final party. Staff, you may call your witness.
Good morning. Staff calls Justin Grady to the stand.
Mr. Grady, if you will please raise your right hand so you may be sworn in by the court reporter.
Good morning.
All right. Mr. Grady, do you swear that the following testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Counsel, your witness.
Thank you. Good morning, Mr. Grady.
Good morning.
Would you please state your name and place of work for the record?
Sure. My name is Justin T. Grady, and I work at the Kansas Corporation Commission.
And what is your current title at the commission?
I'm the director of the Utilities Division.
And are you the same Justin Grady who filed settlement testimony in this docket on September 5th, 2026?
Yes.
Do you have any corrections or changes to make to that testimony at this time?
No, not that I'm aware of.
Okay, thank you. With that, I tender the witness for examination.
All right. Thank you, Ms. Mazenthine. We will move to Commissioner Keene.
Thank you, Chair French. Good morning, Mr. Grady.
Hey, good morning, Commissioner.
Nice to see you this morning. As Ms. Mazenthine indicated and acknowledged in her opening statement, and it may actually be sort of an understatement, that there are many diverse and competing interests that are represented in this docket. Indeed, I believe that is the case. And in the 7+ years that I've been on the commission, I don't know that I recall, it's just a judgment call on my part, another matter where we've had a unanimous settlement agreement that was seemingly so enthusiastically supported by virtually all the conferees. It's really kind of heartening to know that, because I think with respect to not only the company's competitiveness, but the protection of ratepayers, the stakes here are very high. So that's my editorial comment. Now for my question, and I want to give you, I only have one question for you, really, Justin. I want to give you all the latitude that you would like to take in responding to it. And what I'm really asking is, with respect to the potential effect of the settlement agreement in the case that the commission does approve it, with a potential effect on other classes of ratepayers, what assurances do we have that the settlement agreement will truly align the costs and benefits such that the large load customers will actually pay for all the costs associated with with the delivery of their power needs, and that those costs will not be socialized or shared by other ratepayer classes?
Okay, well, yeah, thanks for the question. It's a good one. The assurances that we have are only as good as the data that we have at this point, right? I think you heard Mr. Gorman refer to that in terms of, his testimony is pretty clear that, that his evaluation has been that these rates are set such that they are going to recover the incremental costs that are put onto the system from data center customers or other large load customers, right? And that's because of the analysis and the technical rigor that went into the development of the rates. We obviously didn't take it lightly. It is a very serious matter. These are very large potential customers, several magnitudes larger than the existing largest customer on the system potentially, and they have the potential to cause a significant amount of additional cost on the system. But they also have the potential to absorb a significant amount of existing sort of sunk or fixed costs. And so I think our view going into this was that we recognize the potential, but also the challenge, right? It's an opportunity, but it's also a real concern and a challenge. And so we weren't going to recommend commission approval of anything less than what you just described, right? I mean, our sort of red line was that, look, this, based on all the math and the analysis that we could do, our red line was that if we're going to support a large load tariff in this state, it is going to benefit other customer classes, or there's not really much reason from an electrical system planning perspective to do this, right? I mean, there may very well be economic development reasons to do it. There may be national security reasons to do it. I mean, I know there is an interest that policymakers in Kansas do have an interest in bringing these types of customers to our state. But when we were looking at it, our focus was much more granular than that. It was simply, what are the costs that these customers are going to cause and or absorb, from both a cost and a benefit perspective? That's what our focus was. And at the end of the day, we got comfortable that under these pricing terms at this point, based on all the information we have, it's going to be a benefit to the rest of the customer class to bring these customers on board. And I think the best, the most concrete, quantitative example that I can give you in terms of how you can potentially get comfort with everything I've just said are the rate schedules that I attach to my testimony and support are helpful. I mean, they show you that, we're talking about all-in rates that are, 7 to 10% more than what an existing industrial customer is paying on the system. And that might not sound like much, but when you're talking about an annual power bill of, over $200 million, it's real, right? It's real substantive contribution to the potential, cost sharing, to the allocation of costs that other customers would potentially bear. But the other thing is, if you look at the demand rates themselves in that initial pricing table, and you compare those, for instance, to the incremental cost of building a brand new combined cycle generation facility, right? That we just had a proceeding, we just evaluated those costs in extreme detail. what you'll see is that these customers are basically signing up to pay a demand charge that is, I mean, it's almost indistinguishably different. It's almost the same. Let's just say it's basically the same as the cost of incremental capacity to build a brand new power plant to serve them, right? And that was not accidental, right? That wasn't a coincidence. That was a area of focus of ours on staff. I mean, we wanted to, that was almost like a North Star, or, you know, something that was definitely important for us to keep in mind. We wanted to make sure that, look, these customers, when they come on the system, they're going to be paying essentially an incremental cost rate, right? And, you know, for like the last 30 years, an incremental cost rate was interpreted as a very low cost of basically just absorbing up existing capacity that was excess capacity. Not anymore, right? So today, an incremental cost rate is significantly higher than an embedded cost rate. And that's what you heard Mr. Gorman referring to when you asked him a similar question, right? Of why is this actually going to benefit other customers? And he said, well, because not only are they paying an embedded cost rate, they're paying more than an embedded cost rate. They're paying incremental cost rates, right? And so, you know, the reality is that the way this rate structure is set up, it's designed and very purposeful, very directly designed to not burden other customers, and in fact, actually to benefit other customers. And you know, it'll be incumbent upon all of us as we move forward, because this is just a tariff rate and it can change in future rate cases, but it's going to be incumbent upon all of the participants in future rate cases to make sure that that relationship stays intact, right? And that these new large load customers are actually paying the costs so that they're causing on the system. But in my mind, it's undeniable, it's unequivocal that based on all the evidence we have today, those rates are set appropriately where they're not going to harm other customers. It'll be a benefit to other customers.
Well, Justin, I thank you very much for that. That was a great answer, very holistic, provided a lot of perspective in many different areas. I thank you for your responses. I thank you for your service as well. I have no further questions of this witness.
All right, Commissioner Keither, any questions for Mr. Grady? You're on mute if you are asking a question.
Oh, yeah. Thank you, Justin, for your testimony here. It gives me great comfort with the path that we're on with this agreement and what may or may not happen downtown under the dome, where I don't know that they quite understand everything that they say okay to do and bring in. So it gives me great comfort and grateful for the work that's been done by everybody taking place in this. Thank you.
Thank you.
All right. I do have a couple questions for you, Mr. Grady, but I think we're going to be pretty quick. Your soliloquy with Commissioner Keene there, I think, solved my first major question, and let me just lay it out as I had proposed it. But I think you've solved it with your discussion of an incremental cost rate versus an embedded cost rate. That was very helpful and something I don't think was really fully fleshed out in a lot of the written testimony. The question I really had is there is a lot of focus on how the demand charge is going to bring these rates above cost of service rates, above embedded cost to serve rates, and that these customers will actually be asked to pay a premium. And I kind of had some questions on, well, why is that? And why is that just and reasonable? I think I got my first answer when I looked back at Mr. Lutz's direct testimony where he described the reason for the system support rider, which I understand is sort of the predecessor to the higher demand rates. Yeah, he says it is to reflect the acceleration of resource investment required to serve large loads that join the company's system under Schedule LLPS, as well as other acceleration-related impacts associated with operating new resources. Just to confirm, I'm pretty sure I understand it, but when he talks about the need to accelerate investments, beyond what's needed to serve existing customers, existing load, that's the same thing you're talking about when you say incremental costs, right?
Well, it's kind of the same. Yeah, no, it's unfortunately, I mean, I wish I could just say yes, but I'm under oath, so I have to be a little bit more precise, right? It's kind of the same. The math that went into the system support rider was basically an attempt at moving forward a large capital investment in a generation facility. It was basically capturing the net present value effect of accelerating that investment by 10 years, right? And it's just so happened that when you did all that math, some of which was contested, by the way, right, by the other witnesses in this proceeding, and some of which ultimately, an agreement was made collectively that there should have been some revisions to that. If we had moved forward and fully litigated this, I think you'd have seen a revised schedule. But at the end of the day, there was like some philosophical disagreement about the whole concept, and then there was some discussions about the math and the underlying technical details, and there's probably varying amounts of agreement and disagreement amongst all the different experts in the case. But if you took that revised system support rider and added it to the existing embedded cost, maybe coincidentally, you're going to come out with a rate that's very close to the cost of adding incremental capacity to the system today. Firm, dispatchable, 8760 type capacity, right? And so, that might, it may not have been the case that for every party in the room that they had numbers like what I had in the back of my mind of, $21 to $22 a kilowatt month is that's what it costs to build a new natural gas fired generation facility today, right? But for me, that was like that was a sanity check. That was an important element of that rate to me because I know what this utility faces in terms of its ability to serve new large customers, right? They're basically at capacity, and we know that there are capacity enhancement initiatives underway at the Southwest Power Pool and other. We know the pressures that this utility is facing if it wants to serve a new large 500 or 700 megawatt customer with an 85% load factor. The likelihood is they're probably going to build a power plant to serve that customer. And so that was always in the back of my mind in terms of we can't, it's not feasible, it's not plausible, it's not an acceptable answer if all we're going to do is charge these people embedded cost rates that is in part based on costs to build generation facilities from 1970, right? That's not going to work. And so at the end of the day, we got to the number a little bit differently. Clearly, the parties couldn't agree to a system support rider. The parties didn't agree to an explicit incremental cost of a natural gas fired generation, new combined cycle natural gas fired generation facility. But I'm just pointing out to everybody for the record that those numbers are very, very close, right? It's what they're going to be paying for this initial rate. You could basically build a power plant to serve those customers and recover that cost, right? And that's just the base rates, right? I mean, there's the TDC rate in there that you discussed earlier. There's all the other riders that they're going to pay. And you know what I was so sort of I don't know, not excited by necessarily, but it's satisfying to hear them all say under oath that, look, these are going to be nationally competitive rates. You know, this is going to put Kansas in a good position competitively to actually attract these customers. This isn't just going to be a tariff that's going to sit on the shelf and never going to be used. And so, yeah, I guess that's it for now.
Well, that's really helpful nuance. I had a question that you kind of led into with your last discussion with Commissioner Keene as well. You said it's really important that all of us, keep our eye on the ball and make sure this rate structure stays intact. And my question was, there is a lot of reference in multiple of the settlement testimonies, that these rates are going to continue to be updated as we have future rate cases and we see actual costs come in. But I think what you're saying is, as far as keeping it intact, I mean, the principle of reflecting these new resources and incremental cost to serve should stay intact for LLPS rates. Is that the understanding? And what do you think it means to adjust these rates in future rate cases?
Yeah, so what I would say is you'll probably get a different response if you go back and pull up all of the other witnesses to this proceeding, and but our perspective.
Well, I'm not going to. You get the last shot.
Oh, that's good. Our perspective, my perspective is that admittedly, right, the words on the paper say that everybody reserves their right to take whatever position they deem appropriate in future rate cases, and that's all true. But I think it's going to be a pretty high bar to clear personally, to suggest that those rates should be lowered in future rate cases, especially and unless we're bringing in one of these Evergy utilities and they're significantly over earning, right? I mean, if we're increasing rates, we're being asked to increase rates in a couple of years because of general overall cost increases. I think it's pretty unlikely that these customers are going to get an actual rate reduction. If they are, it's likely to be against the objection of commission staff, right? I mean, what we have in the settlement agreement also for that very first case requires that Evergy take the difference in the demand revenue that is produced under this tariff versus a traditional off-the-rack industrial rate. Take that difference and spread that to other classes of customers, right? And then, in order to get this agreement, that's only binding for one case. And then after that, Evergy has to propose whatever methodology it believes is going to best match the costs created by these customers versus the revenue, the cost responsibility of the customers. But as far, I'm being very open and transparent in that I don't know in that second rate case, right? I don't know of any other method that they're going to use to capture, to ensure that this current rate structure stays in place other than capturing that additional demand revenue and allocating it to other customer classes. In other words, we're probably going to continue to do that type of an evaluation for every future rate case, because we've reserved our rights to do that, right? And now, you know, once you get 10 years down the road, or 7 or 10 years down the road, hypothetically, you have a 500 megawatt customer that's been on the system, you know, contributing these kind of rates for that many years. Well, maybe some of the rationale of tying their rates to incremental costs goes away, admittedly, right? Because they're there now, they're there for 10 years. So, I mean, I don't think there's a perfect blueprint going forward of how we ensure these customers.
Not to cut you off there, Justin, but
Right.
that did spark another thought I had, which is just, you know, if you read Curb's testimony on the settlement, they did raise the concern that, you know, even though this is a long-term revenue commitment, it's not, you know, the length of life of a power plant. And so, you know,
Sure.
is that also some rationale to continue those for maybe longer than you otherwise would have?
Yeah. No, that's a good point. I mean, you know, what I would say is, and all I was going to say is, there's probably not a perfect blueprint for all of us to follow to make sure that these customers continue to pay their cost of service. But there's very infrequently is there a perfect blueprint for us to do really anything that we do, right? I mean, it's just, we just have to all maintain our vigilance and our due diligence and make sure we're doing things correctly. I mean, Evergy will be under a continued obligation to propose a methodology and a class cost of service and a rate design that does that, right? So Evergy's under a continuing obligation for all future rate cases to ensure that cost causation is intact. And then, of course, it's going to be up to all of us, you know, to ensure that they do it right. And, you know, you're absolutely right. I mean, a 17-year contract, right? If they build a new power plant to serve one of these customers, you know, you get 17 years down the road, and it's possible that the customer could close up shop and no longer pay, right? So I mean, that's definitely that is an argument towards why it would make sense to continue to charge this customer those premium pricing levels. This won't be a surprise to you, but we had a lot of conversation about that in those 40 hours of negotiations that occurred. I didn't know anybody was actually, you know, accumulating up those hours, but that sounds about right. I was going to say like 100. It was a lot. But, you know, at the end of the day, those costs, well, actually, I lost my train of thought. Sorry. What?
No, I think that gets me there. I appreciate the response. I
remember. I'm sorry. I'm
go
going to
ahead.
cut you off. I'm sorry. So too much coffee and not enough food. It's 12:13 for me, but I remember now. So look, what I pointed out in those discussions, okay, is if we sign up a new large load customer and they're paying premium prices for the next 17 years, and then there's some hypothetical risk of stranded assets that are created. Everybody on this call knows that Evergy has a very large aging coal-fired generation fleet, right? And I mean, we've been very open and transparent about our desire to keep that fleet operating in the short term for sure, because of reliability and resource adequacy concerns. But everybody on the call also knows that someday those plants are going to retire, right? And you know, they're already nearing 50 years old, many of them, and at some point they're going to retire. And so one of the ways I got comfortable with that mismatch between 40 years of a new plant's life and a customer life of 17 years is 17 years from now, there's probably going to be several of those coal-fired generating units that either already have retired or that are on the cusp of retirement. And I see it as in the public interest if one of the things that allowed that to occur was the fact that there's suddenly this newfound stranded asset capacity that's made up of brand new, highly efficient power plants that were built in 2027 to serve the new large load customers, right? So I know that's kind of all high level and philosophical, but I also think it's reality, and it may very well be the answer if we get 17 years down the road and we're suddenly faced with a lot of excess capacity. So
Yeah, no, that I've kind of had the same thought myself, and I guess to put it another way, it's there'd be a lot of detail to analyze, but it's not necessarily a bad outcome if that transition has to occur anyway in 15 to 20 years, and some third party has funded the first 15 years of it. And then when existing customers need that capacity, it's there, and there's not as much to be paid off. So that's that's something for some commissioner other than myself to deal with, but I do think it's important for us to have a long-term view of that, and I'm glad to hear that was part of staff's rationale in getting comfortable with it. So that's very helpful. I want to finish by asking you just the exact same question I asked Mr. Ives. And it's because you hear so much media attention about, I mean, there literally every day I see a headline that says data centers are increasing retail customers' bills every day. And there's no nuance as to what region they're in or what tariff they're taking service under. But that is the perception that I think the average Kansan has, is that power bills will go up because not just data centers, but large loads are entering the state. I just want to ask you to answer as directly as you can. Again, let's be optimistic. Let's say a 2 gigawatt large load drops itself into Evergy, Kansas Central's territory and signs up for the LLPS tariff. Again, hard to predict what happens, as we were discussing, 15 or 20 years from now, but during while they're taking service under this tariff, are customer rates going up, at least as a result of that customer locating? I know Mr. Ives gave the caveat, obviously, that rates may go up irrespective, but as a result of that customer, are other customers' rates going up?
So I can say definitively, unequivocally, based on all of the evidence that we have right now, based on the data we have, and with the cost structure that we have and the pricing that we have, the answer to that will be no, right? A new large load customer coming into the state of Kansas, if the commission approves this settlement agreement and then we do our jobs on the back end of that, the answer is no. It is not going to increase other customer rates. And that was explicitly by design. That's what one of our objectives was, right? We were not going to recommend approval of this unless we became very comfortable and certain that was the case. There's other interveners as well in this proceeding, right? Mr. Zakura and his client group, they weren't going to be here supporting this if they thought there was any chance that was the case. So the answer is no. That's not going to happen. I see all those same articles, and I think it's kind of a disservice, because what they're doing is they're referring to, as you mentioned, they're referring to a specific region of the country that is experiencing, extreme capacity shortfalls right now. They're in a deregulated environment. They have capacity markets, and that's the only supply attraction mechanism that they have, is a capacity market. The only choice they have really is to signal through those markets extreme shortages and the need to build new investment. And and that's what's happening, right? So I mean, in those areas of the country, those regions, large load data centers and some other entities have basically ate up all of the existing excess capacity of the system. And now they have to build new capacity, and it costs more, right? And so I think the reality is that before about 18 months ago, a lot of these data centers were served under special contracts or economic development riders, and they were served by discounted rates. And so in today's cost environment, with the lack of excess capacity that we have on the system, if you allowed a 2 gigawatt data center to come in and pay an economic development discounted rate, or you gave them a special contract, or even if you allowed them to pay the off-the-rack industrial rate, that other customers' bills may very well go up, right? And I think that's what you're seeing in other states. I mean, the reality is that we are in this proceeding today. Evergy filed the application they did, and the tariff was constructed in the fashion that it was so that Kansas does not end up in the camp of the type of retail rate impacts that have other states and other regions have experienced, right? It's basically, we did everything we did in this large load tariff docket to avoid that happening. And I believe that we got it right. But we can't rest on our laurels, right? I mean, there's probably still some work to be done with regard to cost allocation and for transmission at SPP, right? I mean, there's still a lot of conversations that need to be had. But today, based on everything we have, I can confidently tell you that I think we designed this tariff appropriately, that it's not going to negatively impact other customers. It won't.
Well, thank you, Justin. That was a very direct answer to my question, and was the answer I was hoping for. So, with that, I don't have any more questions for you, Commissioner Keene or Commissioner Keither. Anything final for Mr. Grady before we conclude? Ms. Massentine, any redirect necessary?
No.
All right. Mr. Grady, you may virtually step down. Thank you for your testimony today.
Thank you, sir.
All right. With that, I don't believe there is any plan for the parties to file post-hearing briefing, given that this is a unanimous settlement. And so is there any final concluding matters that we need to address before I end the hearing? Hearing none, this does conclude our hearing in docket number 25 EKME 315 TAR. A commission order in this docket is due by November 25th of this year. If there are no further matters to address, we will adjourn. Thank you all. We are off the record.
Thank you.
Thank you. Bye.
Really quickly before we exit, I understand, council, you all had for your opening statements. If you don't mind to send me the scripts you have for those, or any documents, just to make sure I get everything correct, please, for accuracy. The chat is disabled, I think, or I can do. Yeah, I can give you my email if that would be helpful. Whatever's most helpful.
Brian, do you have Marina's email?
I think Abigail does.
Okay, if you all could get her that.
Yes, please.
Because I know Brian and Abigail should have the opening statement.
Yeah, we've got the Evergy slides if that's what she wants.
Evergy slides, and then just those. I recognize a lot of council just read off some opening statements you have, and I just like to cross-reference just for triple accuracy's sake, for the record.
Yeah, if anybody has your opening statements in written form,
Mm-hmm.
send them to Brian, and Brian will compile all of that and send it on to the court reporter. Sound good?
Sounds good. And Brian, do you want my email just to double check?
I know Abigail's got it, so.
Okay, perfect. Then thank you, everyone. Oh,
Great.
also, sorry, I apologize. Last thing I forgot. If council would like to order a copy of the transcript, would you please state your transcript order for the record?
Yes, I think Evergy would like to order a copy. And that can be this is Kathy Dingus. You can send that and the invoice for that to me.
Okay, perfect. Thank you.
All right. I'm not hearing anybody else requesting a transcript.
Perfect. All right, then that is all I need. Thank you, everybody.
All right. Thank you all. Take care.
Thank you.